질문용이에요.
From 10 a.m., day 2 of the IIPCC conference will begin, so please take your seats.
안내 말씀드립니다. 잠시 후 10시부터 2021 국제 특허법원 콘퍼런스의 2일차 일정이 시작될 예정입니다. 참가자분들께서는 회의장 안으로 입장해 주시기 바랍니다. 2021 국제 특허법원 여러분 안녕하십니까? 저는 어제에 이어서 사회를
Good afternoon. I am Judge Eui-young Jung. I'm going to be the moderator for today's session. So we are going to have for session 5 from now to 12:30, and then we will have lunch break. And starting 2, we will have a moot arbitration, and we are going to end today's session before 4. And we have many panel of judges. We have panel of judges from many different countries today. So I hope today's session will be very informative. In session 5, we're going to talk about Inventor, service invention, and also we are going to talk about the reconciliation or the harmonization of the user's benefit and the employee's benefit as well. So let me introduce our panels.
안녕하십니까.
Good morning.
오늘 세션의 사회를 맡은
I am going to be the MC for today's session. My name is Dong-gyu Kim from the IP Court, Patent Court in Korea. I understand that you might be quite tired after a long day yesterday, but still I believe your passion still remains intact. And I want to first of all thank all the people, all the attendees here, all the speakers and an audience as well. And particularly, I want to thank honorable judges who are going to be the panelists for this session. Due to the time constraint, please refer to their detailed biographies in the booklet. But let me briefly introduce each honorable judge. First of all, from here, we have Young-gi Kim from the Patent Court of Korea. And next, we have Dr. Herman Dreyfus from the Federal Court in Germany joining us online. And we have Honorable James Rodney Gilstrap from Texas Eastern District Court. And he sent us a video clip. And next, we have Honorable Kumiko Katsumata from Japan, the IP High Court in Japan, joining us online as well. And next, from the Federal Court in Australia, Honorable Nai Param, also joining us online. And next, Honorable Mark Schweitzer from the Federal Patent Court in Switzerland. He joined us via video yesterday, but he's here with us via online. And last but not least, Honorable Ji-young Lee from the Busan District Court. And she used to work at the Patent Court in Korea until mid this year. Honorable Dreyfus and Honorable Gilstrap were actually our former panelists from our past conference. And also, Honorable Katsumata and Honorable Param are going to participate in the moot arbitration in the afternoon. It is a great honor for me to introduce this distinguished panel of judges, and I want to thank all of you for your very instructive and detailed answers to the questions that we submitted to you earlier. And particularly, I want to thank Honorable Schweitzer and Honorable Dreyfus for all the information. This session, we are going to talk about employees' invention. Invention often takes place in the context of a workplace. So in the course of working at an employer's site, an employee completes the invention. That is often called service invention or employee's invention. And that invention was made possible due to the employer's resources, human resources, and material resources, and it was completed over the course of the duty of the employee. So there are some issues, for example, who has the patent right and how to compensate for that invention and what should be the law of choice for cross-border issues. There are differences among countries, but basically that invention goes to the employer, but at the same time, the employee is given reasonable compensation for that invention. So actually, our panelists already gave us very detailed answers to the questions that we are going to cover. So for the detailed answers, please refer to our booklet. We are going to cover the source of law, and we are going to cover the requirements and also original ownership and transfer of right and how to calculate the compensation and also cross-border issues and choice of law and some other specific issues regarding litigation. So basically, we want to reach a harmonization between the employer's interests and also employees' interests. Because we are covering so many issues, we cannot give enough time to each panelist, so I apologize for that. But if you can answer briefly, that will be great. Thank you.
The first subtopic of the fifth session is the source of law regarding employees' invention. So with regards to employees' invention, some countries have statutory laws while others follow the employment agreement. The panelists, please present on the legal relationships and requirements and scope of employees' inventions and standards for determining compensation. Especially in case of Germany, in 2009, the Employee Invention Act was amended, and in 2015, Japan's Patent Act was also revised, as far as I'm concerned. So please, panelists from Germany and Japan, please elaborate on such amendments and how it is being received in the judicial practice and industries. Please limit your answers to 2 minutes. First, we will hear from President Schweitzer.
Good morning, everybody. I have a problem with my voice, as you can hear, and I can hardly speak. So I hope you can hear me. The Swiss law on employee inventions is actually very simple. Service inventions, which are inventions which are made in performance of contractual duties, automatically belong to the employer, and there is no special compensation due for such inventions. So they belong, it is assumed that the compensation for such inventions is by the regular salary, because it is the duty of such people employed in research and development also to make inventions. So it is very employer friendly and it is very, very simple. On the other hand, if there is an opportunity invention and the definition is basically the same as in German law, then there is a special compensation due. However, cases of opportunity inventions, which are inventions which are carried out in relation to the work, but not in performance of contractual duties, they're extremely rare. And therefore there is very few cases, or actually no published cases to my knowledge, where the issue of compensation arises. So I would say, to be very short, and I really apologize, I'm not sure how long I can go on. The law is very, very employer friendly and basically assigns all rights in service inventions to the employer without any extra compensation for the employee. And with this, I will finish. Thank you very much.
Thank you, President Schweitzer. And now Judge Dreyfus, floor is yours.
Hello, yes, can you hear me? Good morning to Korea. Very glad to be here. The legal relationships surrounding employees' inventions are regulated in Germany by the Employee Inventions Act of 1957. There have been little changes since then. The latest amendment, as you mentioned, was in 2009. The object of this last amendment was to simplify the rules. Most important was the modification of Section 6. Until 2009, the employer had explicitly to claim the invention. Nowadays, the claiming of the invention shall be deemed to have been declared unless the employer expressly releases the service invention by making a statement in text form addressed to the employee. So if you're an employer and your employee informs you about the invention and you just do nothing, the right is transferred to you, but you have to pay a reasonable compensation. Thank you.
예, 답변 감사합니다.
Thank you for your answer.
판사님 답변 부탁드리겠습니다.
And next, Honorable Ferm from Australia, please.
Good morning. Thank you for inviting me to speak. Under the Australian Patents Act 1990, the particular position of employers and employees is not expressly dealt with. It therefore is worked out through more general provisions in the Act dealing with ownership and the entitlement of a party to apply for a patent. The two relevant categories which are relevant to the employer situation are in Section 15 of the Act. That concerns the entitlement of a person to apply for a patent who would be entitled to an assignment of the patent and the right of a person who derives their title to a patent from another person. The Act doesn't go any further than that. In practice, what that means is that one needs to look at what the common law says about those two topics. In the particular situation of employers and employees, the relevant part of the common law is that part dealing with employment contracts. Generally, if the employment contract deals with the matter expressly, it will prevail. If the employment contract is silent on the question, then the courts will imply terms into it dealing with the issue. Speaking very broadly, the basic rule is that if the contract is silent and the employee comes up with the invention or discovers the process or the method in the course of their duties for the employer, that is doing what it was that they were actually hired to do, then the invention will belong to the employer. If the invention doesn't fall within that categorization, it will belong to the employee. Thank you very much.
예, 답변 감사합니다.
Thank you very much for your answer. And next is Honorable Katsumata from Japan.
Yes, hello. I'm Kumiko Katsumata, Judge of IP High Court, Japan. I'm pleased to join the session. And my answer is as follows. In Japan, employees' invention is regulated by a statute. Article 35 of Patent Act provides that first, the employee has the right to the grant of a patent for an employee's invention. Second, the employer shall have a non-exclusive license on the patent right of the employee's invention, and that the employee shall have a right to receive a reasonable compensation for transferring the right over the invention to the employer. Article 35 was last amended in 2015 as the moderator introduced. You can see the background and the point of the amendment in the reference book and also slide number 6 in detail. The points of that amendment are as follows. Yes, thank you. And at first, an employer is allowed to become the original acquirer of the right to the grant of a patent of employee invention through a contractual arrangement or an employment regulation. 2, the employer shall receive reasonable benefits. Before that amendment, the employee is supposed to receive only money as a reasonable compensation for transferring the right over the invention to the employer. However, now an employer can compensate with any kinds of benefit, such as money, stock option, giving the chance to study abroad at the employer's expense, a rising salary, a paid holiday, and licensing a parent. 3, the Minister of Economy, Trade and Industry is to establish guidelines. The guideline has been published on 22nd of April 2016. Thank you.
예, 답변 감사합니다.
Thank you very much for your answer. And next, Honorable Young-hee Kim.
Good morning, everyone. It's my great pleasure and honor to be the panelist for this meaningful session with the renowned judges from diverse countries. From now on, however, please understand me that I proceed in my mother tongue Korean for the audiences on site, and for more accurate delivery of Korean practices. Okay. 지금부터 답변 드리겠습니다. 한국에서는 발명진흥법에 의하여
So according to the Korean Invention Promotion Act, there are some specific rules regarding employees' invention. For example,
관하여 발명한 것이
if employee makes the invention over the course of the duty, and if the duty falls within the scope of the business of the employer,
속하는 발명을
and if the invention is related to the duty activities of the employee, then that is considered employee's invention.
그 특허권
So regarding that, the employee has a non-exclusive license regarding such invention.
특허권을 계약이나
But it also depends on the contract and employment regulation that the employee can transfer the right to the employer. In that case, the employee is entitled to reasonable compensation.
한 것으로 봅니다. 다만 그 보상액이
However, the amount of the compensation
그 발명의
should consider the benefit that the employer will get by using that invention. If there is no such benefit to the employer, then then the compensation is not considered.
사용자를 상대로 법원에 그 정당한
And also, sometimes there is a litigations by the employees for compensation from the employer for the employee invention.
미리 동영상을 보내주신 동영상을 시청하고
Now we will watch a video that Honorable Judge Gilstrap sent us from the United States. It will run for about 7 minutes. Thank you.
Hello, my name is Rodney Gilstrap, and I am the Chief United States District Judge for the United States District Court for the Eastern District of Texas. It's a pleasure and an honor for me to be a part of this 2021 International IP Court Conference. Let me begin by thanking everyone that's played a role in bringing this about, jurists from around the world, various organizations. It's, as I say, an honor to be a part of this. I'm also honored to be part of a very distinguished panel of IP professionals, judges from around the world, and I know that our topic will be handled virtually as rather than in person. Would have certainly been nice to be in person, but that's not the world in which we find ourselves these days. Our topic has been relegated to the area of employees' inventions, and from an American perspective, I can tell you that the key issue of underlying inventorship is subject to both statute and case law here in the United States, as well as certain internal rules of the United States Patent and Trademark Office. The primary statutory source regarding inventorship is what we commonly refer to as the Patent Act, found in Title 35 of the United States Code, beginning at Section 100 and following. There are numerous opinions from the United States Court of Appeals for the Federal Circuit, as well as our United States Supreme Court, and numerous district court cases from around the country that, when these issues arise, are sources of input, precedent, and guidance. It's clear that where an inventive process occurs within the scope and the course of an employee's employment, that both the employer and the employee may have certain rights relating to that work product. In the United States, those issues are typically dealt with in most cases that I can find. In most cases, those are dealt with by the employment contract underlying the relationship between the employer and the employee. And consequently, the disputes that arise from the inventive process occurring in the workplace almost uniformly involve issues of contract law more than they do definitional guidance as to inventorship under patent statutes and precedent. In most sophisticated employment situations, an employee signs a written employment contract in advance of beginning work, and in most cases that contract, along with many other provisions, contains specific contractual provisions regarding what happens when the employee is involved as a part of their employment with the development of new ideas, methods, processes, etc., that may ripen at some point into a patented invention. And when these issues that later lead to cases being reported develop, they're mainly in the context of a former employee, a lot of times, or an employee still employed who's embroiled in a dispute with their employer about their rights in a patented invention that comes out of the workplace. Consequently, the first place that most courts turn is the underlying contract between the employer and the employee. And in many cases, those contracts are very straightforward. Many employers provide contractual provisions that their employees consent to as a condition of accepting employment, that any and all rights they might have as a participant in the inventive process are the property of and inure to the benefit of the employer. There can be, as in any contract, there can be negotiated provisions that are all on one side or the other or somewhere in between, and there can be and there have been disputes that develop about the contractual rights of the competing parties in this kind of a situation. But by and large, the American case law, I've found, finds itself dealing with employment issues, contract issues, more than underlying patent statutes. There may be references in those contracts to inventorship and other concepts that may even reference the Patent Act or the rules and regulations of the Patent and Trademark Office. And in those cases, that may open the door to more of a patent precedent application in those disputes. But in most cases, they boil down to, at the end of the day, contract disputes that go back to an underlying written employment contract. And again, this is where we have sophisticated employers and sophisticated employees. Now, certainly, you can have employment relationships in the United States where there is no written employment contract. But those are more likely than not going to be in less sophisticated settings where the development of important IP is less likely to happen. I won't say that that can't be the case, but it's the sophisticated employer and employee that address these things in employment contracts when this kind of an issue is going to be looked at, much more so than the handshake, unwritten employment relationship that can exist but rarely finds itself overlapping with the inventive process in a workplace that results in patented inventions coming out of that. So in an American context, you're probably going to be looking primarily at a written contract of employment. That's going to be construed by the courts where it references underlying statutes from the Patent Act, where it references rules and regulations of the Patent and Trademark Office. Then those kind of purely patent issues may come in, but they're going to come in as a part of construing and enforcing a contractual provision in the vast majority of cases. I hope this has been helpful. I know it's short, and I want to make sure I save plenty of time for the other members of my panel, because we have some of the most knowledgeable and learned people in the world on these topics that I want to make sure they have plenty of time to weigh in. So that's my perspective.
예, 답변 잘 들었습니다.
Thank you for your answer.
다음 주제로 넘어가겠습니다.
We will move on to our next topic. It is the recognition requirements for employee invention and the transfer of the rights. So here comes the first question regarding requirements and scope of recognition. Are all inventions completed by an employee during employment seen as employee's inventions, or only those made during performing duties during employment and when the employee used the employer's facility and equipment? And next, how do you distinguish employees' inventions and free inventions? And for free inventions, is the employer still entitled to claim assignment of the right to acquire a patent or royalty-free non-exclusive license? And in case of Switzerland, please distinguish the opportunity invention from service inventions. Please elaborate on it. Thank you. First, we will hear from Judge Katsumata from Japan.
Okay, in Japan, with regard to the requirement for the employee's invention, Article 35, Section 1 of Patent Act stipulates that an employer's invention as an invention which, by the nature of the said invention, falls within the scope of the business of the said employer and was achieved by an act categorized as a present or past duty of the said employee performed for the employer. So in Japan, according to Article 35 of Patent Act, employees' invention should be achieved by an act categorized as a present or past duty of the said employee. In addition, the employee's invention should be achieved by an act performed for the employer. If the requirements are not satisfied, the invention will be a free invention. So with regard to so-called free invention, the employers that do not have any kinds of rights. Article 35, Section 2 of Patent Act does not allow that any provisions in any agreement, employment regulation, or any other stipulation providing in advance that the right to the grant of a patent or the patent right for free invention is acquired by the employer. Thank you.
Thank you for your answer, Honorable Judge Katsumata. And now we will hear from Judge Param from Australia.
As I said before, the question in Australia of who owns, as between the employer and the employee, the patent or is entitled to its registration, is governed by the terms of the employment contract. If the employment contract is silent, then the common law will imply a term into the contract that if the invention or the discovery was made in the course of employment during doing the thing which the employee was hired to do, then the employer will be entitled to it. That was established by some federal court decisions called Gray and Victoria University. If that requirement is not met, then the employer will not be entitled to the patent. To be clear, that means, so in terms of the second question, that it is not enough that the employee did the work at the employer's premises or with the employer's tools or on the employer's time. It is necessary in order to meet this requirement that the invention or method or process be done by the employee as part of the job which the employee was hired to do. In terms of the third question, Australian law doesn't recognise the right of an employer to a free non-exclusive licence or a right to transfer unless this can be found in the terms of the contract itself. Thank you.
예, 답변 감사합니다. 다음은 스위스 슈바이처
And
법원장님.
next, Honorable Schweitzer from Switzerland. Honorable Schweitzer from Switzerland.
저 스위스 원장님, 슈바이처 법원장님 마이크 켜주시기 바랍니다.
I think you're on mute.
Yes, I'm sorry. I forgot to unmute, but even unmute, I have a problem with my voice and I'm really starting to struggle here. So basically, the invention has to be made in performance of contractual duties. And if it is made in performance of contractual duties, then all the rights will rest from the very start with the employer. If the invention is made not in performance of contractual duties, but merely on the occasion of the job, even using facilities, then the rights rest with the employee. However, the employer may reserve by written contract the right to claim such an invention for his own purposes, but then must pay a special compensation to the employee. But this only in case of opportunity inventions, not in the case of service inventions. And finally, the third question, there is no statutory basis for a license for the employer for free inventions. Of course, the parties can agree contractually to such a license, but without any specific contractual agreement, there is no non-exclusive license or right to claim transfer of so-called free inventions, which are done outside the employee's obligations and outside his work. But of course, you can agree to that if you do that. But the employer does not have a right from a statutory point of view. Thank you.
예, 답변 감사합니다.
Thank you very much for your answer. And next,
독일의 다이프스 판사님.
Honorable Deifser from Germany.
Yes, thank you. The German Employee Invention Act distinguishes between tied inventions or service inventions on the one hand and free inventions on the other hand. You find the rule in section 4. Service inventions are those made during the term of employment and either result from the employee's task in the enterprise or are essentially based upon the experience or activities of the enterprise. Any other invention of an employee is regarded as a free invention. As regards service inventions, they are originally an invention of the employee, but the employer can claim for the invention. As regards free inventions, the employee who has made a free invention during the term of an employment contract shall notify his employer by making a statement in text form thereof without delay. And the law says before exploiting a free invention, further during the term of his employment contract, an employee must offer his employer at least a non-exclusive right to use the invention on reasonable terms if the invention falls within the range of the actual or planned activities of the employer's enterprise at the time the offer is made. And where the employer does not accept the offer within 3 months, this prerogative shall lapse. Thank you.
예, 답변 감사합니다.
Thank you very much for your answer. And next, Honorable Young-gi Kim from Korea.
내용을 말씀드리겠습니다.
Let me talk about Korea situation. So,
분 중에 일본, 독일과
as honorable judges from Japan and Germany mentioned, we have a similar situation. So first, whether invention was invented over the course of the duty by the employee. And second, what about the contents of the invention? Is it within the scope of the duty or the business of the employer? It means that the employee's duty is related to the business operation of the employer. And also, the inventive action, is it part of the duty of the employee? That is another consideration. So it means that given the tasks of the duty and the scope of the duty, it is naturally expected to arrive at such invention. Regarding free invention, Korea differs from Germany and Switzerland. So the Promotion Invention Act has different treatment for free invention compared to employee invention. So free invention is a comprehensive concept that does not satisfy the recognition requirements of the employee invention. So in that case, the transfer, the patent right transfer, or exclusive license, or these things, if these things are written in the employment regulation, they are considered null. So, if the employee's invention is within the scope of the business of the employer, but the scope of the invention is not within the duty of that person, then there's a discussion that the two need to be distinguished. Thank you very much.
목이 불편하신데도
President Schweitzer, well, thank you that despite your conditions are not at best, still you are taking part of this session. Thank you very much. We appreciate it.
이번 질문은 직무발명에 관한 권리
So now we will move on to the next topic of the ownership of the rights. So if the invention is completed, then who originally retains the right to the invention in your country? If your country upholds the inventorship principle where employee originally retains the right, then what kinds of procedures or requirements is necessary for the rights to be transferred to the employer? And is the employee obliged to notify the employer upon completion? And if the employee does not notify, then is this a breach of obligation? And is there some kind of liability? And is pre-invention comprehensive assignment agreement recognized in your country? If so, what are the requirements? And if the employer does not succeed rights for the invention, is the employer still entitled to rights such as royalty-free, non-exclusive licensee? On the other hand, if your country upholds the ownership principle where the employer originally retains the rights to the invention, is the employee liable to still notify the employer upon completion of the invention? If the employer waives rights to the invention, is the employee entitled to the rights? For the case of Germany, also please let us know if this applies to the case of free inventions, the notification liability. Please limit your answers to 3 minutes. First, we will hear from Judge Dreyfus from Germany. Honorable Judge Dreyfus? I think we are experiencing technical difficulties. Then let's move on to Judge Katsumata from Japan first. The floor is yours, Honorable Judge Katsumata.
Yes, okay. To talk about the original ownership of the employee's invention, basically, Patent Act of Japan adopts inventorship principles. Patent Act of Japan provides that the employee, that is the inventor, is entitled to the original ownership.
Can you hear me now? Can you hear me now? Can you hear me? Oh, thank you. It was interrupted. According to German law, the employee has to report the invention to the employer.
Honorable Judge Dreyfus? Sorry, we were already listening to Judge Katsumata, so let her finish and then we'll move on to you. Thank you. Sorry for this difficulty. So please go on, Judge Katsumata. Please go on with your answer.
Okay, where is it? Yes, the patent of Japan provides that the employee, that is the inventor, is entitled to the original ownership when the employer does not conclude the succession agreement with the employee. Nevertheless, the employer is entitled a free, non-exclusive license of the employee's invention patent. However, if the patent is granted to the free invention of the employee, the employer does not have any rights to the patent. In order to succeed in the ownership of the employee's invention, there are two types of procedures the employer can take. One is the individual agreement between the employer and the employee about transfer the right over the invention before or after the invention. Second way is to enact an employment regulation about ownership of the right over the invention or about transfer the right over the invention prior to the invention. In most cases, the employer chooses the second procedure, and then the employee's invention shall be transferred to the employer or shall be vested in the employer according to the employment regulation. And next, with regard to the notification, in Japan, the statute, the Patent Act does not require the employee to notify the employer of the completion of the invention. The ex-ante agreement on succession of employee's invention is valid when the conditions are comprehensive. However, the ex-ante agreement on succession of free invention is invalid, as I mentioned before. Thank you.
예, 답변 감사합니다.
Thank you for your answer. Now, let's go back to Judge Dreyfus from Germany.
다이프스 판사님.
The floor is yours.
예, 다이프스 판사님 들리시나요?
Yes.
예.
Sorry, my connection was interrupted. I'm afraid. Do you hear me now? Okay.
예, 잘 들립니다.
Yes, we can hear you.
According to, do you hear me?
예, 잘 들립니다.
Yes,
예, 답변 부탁드리겠습니다.
we can hear you fine.
Ich verstehe kein Koreanisch. I don't understand Korean. Do you hear me?
Yes, we can hear you fine.
Okay.
Please proceed.
According to German law, the employee has to report the invention to the employer. There are rather detailed rules for this report. See Section 5 of the Act. The employee making a service invention is obliged to report the invention to his employer immediately in a special note in text form. He has to indicate that said writing constitutes the report of an invention. In this report, the employee must describe the technical problem, its solution, and how he arrived to the service invention. He shall attach any existing notes necessary for an understanding of the invention. The report shall include the service instructions and directions received by the employee, the experience and activities in the enterprise of which use was made, the employee's co-workers, and the nature and extent of their contribution, and the report should underline the contribution which the employee making the report considers to be his own. In this way, the employer is provided with the information necessary to decide whether he wants to claim the service invention. The employer has the right to claim a service intention explicitly without formal requirements. It's a special characteristic of the German law, I mentioned it earlier, that the claiming of the invention shall be deemed to be declared unless the employer expressly releases the service invention by making a statement in text form addressed to the employee. On claiming the invention, all property rights in the service invention shall pass to the employer. However, if the employer does not claim the invention, all rights to it stay with the employee. There is no such thing as a free, non-exclusive license for the employer according to German law. As regards free inventions, I already mentioned that the employee has to notify a free invention as well. Thank you.
예, 답변 감사합니다.
Thank you for your answer.
한국의 김영기 판사님, 답변 부탁드리겠습니다.
Thank you. So, as honorable judges from Japan and Germany mentioned, certain countries accept inventorship, and Korea is similar. And I understand that ownership principle is adopted by Australia and other countries, but here in Korea we adopt inventorship. So the original ownership goes to the inventor, the employee, and also the employer, depending on the contract or employment regulation, the employer can receive the transfer of the right or exclusive license. And the employer can get the royalty-free non-exclusive license for such non-exclusive license. And also, upon the invention, the employee needs to give the written information to the employer. And if the employee does not satisfy this obligation, then depending on the regulation, employment regulation, the employer needs to let the employee the transfer of the right, and also the patent right and the transfer succession that needs to be part of the employment agreement, and it could be a pre-invention agreement, which is similar to Japan. And for other free employment, employer may receive the transfer of the right or the ownership in the employment regulation, but that will be nullified. However, if the right is given to the employee, then it doesn't mean that the entire regulations are nullified, but depending on the duty of the employee, certain terms are valid. And next, Honorable Schwartz from Switzerland.
Yes, thank you. So, in case of service inventions, okay, I'm sorry, I'm really just about to finish. So in case of service inventions, the right rests originally with the employer, no transfer is required. In case of opportunity inventions, the employee must notify in writing, and then the employer has 6 months to claim the invention. If the employer does not claim the invention, he has no non-exclusive license or such thing. In this case, the invention belongs to the employee, but this is only for opportunity inventions. There are no more specific regulations other than a notification in writing. So unlike in Germany, where it is very specific, it is more of a general obligation without further specification. You may agree in advance to the assignment of inventions, but in the case, no, I should say, in the case of opportunity inventions, you may not agree in advance. You have to do it for each specific case, and you have to pay the special compensation. And in the case of service invention, the question doesn't pose itself because the ownership lies with the employer. So it's an ownership country. What other questions do we have? Yes, I think I answered most of these questions. And I'm sorry if these answers are a bit general. Neither the statute nor the case law in Switzerland is very specific on these questions. There is not that many cases that actually go to court. And with this, I will bow out. I'm sorry.
Thank you very much for participating despite your throat pain. And next, Honorable Ferran from Australia.
Thank you very much. A little like the Swiss situation, there's not a lot in Australian law about this. As to the first question, as I've said, the question of whether the employer or the employee is entitled to the invention is governed by the contract. And as I've explained before, where the contract's silent, the employer will be entitled to it, effectively where the employee has come up with the invention as in the performance of what the employee was retained to do. On the topic of transfer, if an employee as inventor obtains the grant of a patent in his or her own name under Section 15(1)(a) of the Patents Act, in circumstances where under the employment agreement, either express or implied, the patent should belong to the employer, then Australian law would resolve that potentially in a number of ways. In the real world, it would probably resolve itself in a proceeding before the Patents Office seeking a rectification of the Register of Patents, or perhaps unwisely a revocation of the patent. In hearing such a dispute, the Patents Office is entitled to delve into the details of the contract. Perhaps a little less realistically, it would be open to the employer as a matter of industrial law to seek to enforce the terms of the contract in a suit for a contract case. And because ownership's rights are involved, it would also theoretically be possible to assert that the patent was held on trust. However, the rectification of the register process is by far and away the most practical way that would be resolved. Turning to the fourth question, this does not really correspond very well with the Australian position. If the employer is entitled to the patent, there's no procedure requiring the employee to notify the employer of the completion of the invention. If the employee sought to conceal the fact that the invention had been created or that it had been completed, there would be private law remedies available to the employer outside the scope of patent law. And these would include actions for breach of a duty of good faith, or if the employee were a senior employee, a breach of fiduciary duty. Again, however, probably the most practical route which would be taken is to apply to the Patents Office for a rectification of the register, or perhaps revocation if that were thought appropriate. Thank you very much.
답변 감사합니다.
Thank you.
다음은
I have one additional question for Judge Dreyfus. According to Articles 6 and 7 of the Employee Invention Act, it seems that the right to an employee's invention is assigned to the employer unless the employer waives such right to claim assignment. But the Section 22 still does not allow an agreement to be made in advance for comprehensive assignment. Why is that? Please limit your answer to 1 minute. Judge Dreyfus, the floor is yours.
Thank you. Actually, there is no judgment of the Federal Court of Justice on this issue or of any other German court, as far as I can see. But all authors concur that such an agreement is not allowed according to Section 22. The employer has to make up his mind whether to claim the invention or not in every single case. But as you have pointed out, this is not of much relevance because Section 6 and 7 state that the right in the service invention shall pass to the employer if he does nothing. It's just enough to wait after the notification of the invention. So I think there's no need for such an agreement according to the German law. Thank you.
예, 답변 감사합니다.
Thank you.
예, 다음 소주로 넘어가겠습니다.
And let me move on to the next topic.
이번 질문은
So the next question is about how to transfer the right without consent from the without notifying the employer. So what if the employee transfer the right to a third party without notifying the employer, and that third party got the patent on the invention? What can be done in that case for the employer's perspective? Any civil procedure or criminal procedure? What kind of penalty or obligation for the employee? And in that case, does the patent held by the third party valid? Honorable Dreyfus from Germany, could you answer first?
Right. The German Employee Invention Act states that any disposition of a service invention made by an employee before the employer has declared claim shall have no effects on the employer insofar as his rights are prejudiced. It's section number 7. If, for example, the employee files a patent application and transfers it to a third party or grants a license, this disposal is invalid in relation to the employer. If the employer finds out about the application, he still has the right to claim the service invention. If he does so, all property rights shall pass automatically to him, not encumbered with third-party rights. That is true even if the third party has acted in good faith. The third party is limited to claims for damages against the employee. The employer can claim for damages against the employee. Moreover, he can claim for damages against the third party for their culpable acts of exploiting the invention. In one case, Rasenbefestigungsplatte, that's the name of the case, the employee had pretended to have made the respective invention after the ending of the employment relationship. In reality, he had developed it during the employment. Therefore, the deceived employer did not claim the invention. The employee filed a utility model and exploited it together with a third party. When the employer found out he was deceived, he claimed the service invention and he sued the employee and the third party. They were condemned to pay damages. If the employee acts intentionally, he can be held liable for fraud. Thank you.
예, 답변 감사합니다.
Thank you very much for your answer.
판사님,
And Honorable Katsumata from Japan.
Yes. In Japan, at first, the employer can recover the patent right by obtaining a declaratory judgment pertaining to the right to obtain a patent against the person who filed a misappropriated application, and by filing an application for change of the name of the applicant before JPO stands for Japan Patent Office before the patent registration. If the patent has been already registered, the employer can recover the patent right by requesting for the transfer of a patent right against the registered patent holder before the court. In this case, the employer files an application for change of the name of the patent holder before JPO after obtaining judgment document. In addition to that, the employer can claim damages arising from violation of the ex-ante succession agreement against the employee. In case when the third party filed an application, nevertheless, it was aware or negligently unaware that the employee was not the right holder, the employer can claim damages also against that third party on the basis of tort. And we don't have any criminal punishment in that case, but it could be a kind of fraud. Thank you.
예, 답변 감사합니다. 다음은 한국의
Thank you. Now we'll hear from Judge Kim for Korea.
네, 오늘 컨퍼런스가
So Today's conference is on the subject for employees' inventions, and we are listening from 5 different countries. As I was preparing for this conference, the concept of how to define the concept of employees' inventions and what are the source of law, actually, I really pondered about this, and actually 3 countries took the stance of inventorship, and Switzerland takes ownership. So Germany, Japan, and Korea are the 3 countries that have inventorship in place, and that is why we are answering this question. But if we go into detail about how each country specifically regulates this issue, among the 3 countries, I think we are looking at some differences. Now, when it comes to Korea, well, since it was transferred to a third party, if it was actively breached, if the third party was willingly knowing when they got the transfer, that is the case that we are looking at. This is double assignment, and according to the Civil Act, it is such transferred rights is invalid. So through administrative invalidation suit, that is one of the remedies that the employer can pursue, and even if the such suit is not filed, subsequent filing will grant justifiable rights to the employer, and also the employer can file for transfer. And the pre-invention agreement was breached, so the right to file for transfer lies with the employer. So, for the preservation of the rights, if the subrogation can be applied when it comes to the third party. If the third party actively participated, it's a different story. But if the third party did not know about such relations, then the right that is transferred to the third party would be valid. So the employee can no longer transfer the rights back to the employer. So the only methods that the employer can take is civil procedures to claim the rights. To go into a bit more detail, the employee would be liable for default and also breach of trust under civil liability. And if the third party actively participated knowingly, then the third party would be liable for joint tort. And for the employee and a third party who actively participated, they can also be criminally punished under the crime of breach of trust. Thank you. Thank you so much for the answer. And now we will hear from President Schweitzer.
Thank you. So in case of service inventions, the employer can sue for recognition of his original ownership. In case of opportunity invention, he can sue for transfer, and the employee would be liable for any financial damages if he filed such a patent in his own name. There is no criminal responsibility. Now, in case of third parties, the question is a bit more difficult. If the third party is aware that the invention did not belong to the employee, but it belonged to the employer, the third party could, in principle, be liable for financial damages. If the third party was not aware, so he acted in good faith, he would not be liable for damages. And so if the third party, this is actually an interesting question, if the employee registers the patent and is, according to the patent register, the registered owner, and only afterwards transferred the patent application or patent to a third party, and such third party is in good faith, so is unaware that this is not the correct owner that is registered, it is actually disputed whether he would acquire the rights in good faith or whether the original owner, which is the employer, still has a right to transfer the application or the granted patent. This has not been decided yet by the Supreme Court whether there is a reliance interest on the patent register. It is very disputed in the literature. And with this, I will finish. Thank you.
예, 답변 감사합니다.
Thank you.
호주의 페람 판사님.
Now, Judge Param from Australia, the floor is yours.
The employee as inventor is a person who's entitled to apply for a patent under Section 15. If the employee comes up with the invention in the course of the employee's invention, then the employer is also a person who's entitled to apply for a patent. In general, the patent will be granted by the Patents Office to the person who is the owner of the patent. In the circumstances of the question, the employee has applied for the patent as entitled to do under Section 15, but is not actually the owner. So the employee ought not to have been registered. As against the employee in that situation, it would be relatively straightforward for the employer to have the register rectified. The situation is more complex, of course, when the employee wrongfully transfers the patent to a third party. I think it's necessary to distinguish two situations. The first is what's appearing on the register. The second is what kind of remedies, compensationary, restitutionary might be available. As to the first topic, the employer would be entitled to get the register rectified to have the patent put back in the employer's name, and that would be so whether the third party was on notice of what had happened or not. On the question of compensation, the situation is more complex. It's unlikely that a claim, for example, for profits would lie against the third party unless it could be shown that the third party was, in a sense, complicit in the breach which had happened. Thank you.
예, 답변 감사합니다.
Thank you for your answer.
벌써 이번 세션에 거의 절반이 지났습니다. 잠깐 스트레칭을 좀 하시고.
So actually, already half of the session has passed. Let's take a short 30-second break. How about that?
시간이 깁니다.
Because we are about to move on to a very lengthy topic.
짧은 휴식을 마치고 세션을 수행하도록 하겠습니다.
So we are going to resume. I hope you enjoyed a very quick rest. And now I think this is going to be the most hot topic for Korean participants here because we are going to talk about compensation obligation and guideline for employee invention. So regarding the rights of the employee invention, whether the employers has the obligation to compensate the employee. If that is the case, what is the guideline for calculating the compensation? And what are the contents of the guidelines? Are the guidelines legally binding? And how are they actually practiced in Korea? Thank you very much. Please limit your answer to 2 minutes.
먼저 호주의 페람 판사님.
Honorable Ferram from Australia first, please.
Thank you. So because of the ownership approach taken under Australian law, whereby either the employer or the employee is going to be the person entitled to the patent, or perhaps they'll be entitled jointly. We don't really have any provisions of this kind. So that is to say, there is not an explicit mechanism where the employee ends up in the position of having the patent providing for compensatory arrangements. So this question and the next few questions which follow don't really give rise to a question for us. Thank you.
Thank you very much for your answer. And next, Honorable Dreyfus from Germany.
The Employees Inventions Act states in Section 9 that the employee is entitled to reasonable compensation. This is rather vague, but for a more detailed answer, we have guidelines for compensation. These guidelines are issued by the Federal Minister of Labor after hearing leading organizations representing employees and employers. It is common to adopt the criteria specified in Section 9 and in the guidelines for calculation of compensation. This is true for compensations established by agreements, by settlements, and for compensations fixed by the employer. This is also true for lawsuits seeking payment of compensation for an employee's invention. The guidelines do not have a binding effect, but provide, in addition to the provision in Section 9 of the Employees Invention Act, a guide as to which compensation is reasonable. As I've already mentioned, it is common to adopt these criteria specified in Section 9 and in the guidelines for calculation of compensation. Thank you.
Thank you. Honorable Katsumata from Japan, the floor is yours.
Yes. In Japan, the Minister of Economy, Trade and Industry established the guideline about the procedure. The employer established an employment regulation over the employee's invention. The guideline is not a regulatory, so I think it is not binding. It has only a kind of an advisory effect. With regard to the contents of that guideline, it shows what kind of elements the employer should take into consideration upon establishing the employment regulation regarding the employee's invention. The guideline includes, following points. 1, when the employer negotiates with employees about the regulation, they should discuss with the matter satisfactorily, but they need not to reach an agreement. 2, after the negotiation, the employer should disclose the draft of the employment regulation to the employees. 3, after the disclosure, the employer should hear the employee's opinion about the draft before establishment of the regulation. 4, to revise the employment regulation, the employer should negotiate with the employees about the revision. 5, examples of reasonable benefits as compensation are money, giving the chance to study abroad at the employer's expense, stock option, promotion with a rise in salary, paid holiday, licensing a patent. Thank you.
Thank you. We will hear from Judge Jiyoung-ii from Korea. In case of Korea, Article 15 of Invention Promotion Act stipulates that the employer is assigned patent right regarding the invention and responsible for paying appropriate compensation, but there is no guideline with binding force in Korea. But the industries have long argued that such guideline is much needed. So based on such request from the industries, currently KIPO is leading efforts to establish such guideline via research. That would be it. Thank you.
다음은 스위스 슈바이처 법원장님.
Now, let's hear from President Schweitzer from Switzerland, but his throat pain was so severe, so it was impossible for him to speak during the session. We really appreciate that you stayed until now to take part in the session. I really hope that you feel better soon.
다음 주제로 넘어가도록 하겠습니다.
And let me move on to the next question. What are the calculation methodology for the compensation? So, does that mean that there is a law that oblige calculation? I guess certain countries have that law, so those countries' representatives are going to answer this question. So we have specifically two questions. So first of all, when the employer, how is the compensation calculated when the employer takes the patent right, and what are the factors to consider, particularly if the employer and also the employer's total benefit from the invention is considered, or benefit from the exclusivity of that invention is considered. What about the remainder of the patent term? What about the future revenue? Is it considered? And also, what about other revenue elements? And how is the license royalty considered? Thank you very much. Please limit your answer to 2 minutes once again. First, Honorable Dreyfus from Germany.
Where the employer produces and sells the employee's inventions products but provides no license for the third party, the compensation is calculated as follows. The first factor to be determined is the value of the invention. The invention value shall be determined by license analogy. What license rate would the employer have to pay to a free inventor for an exclusive license? The license rate may be expressed as percentage or as a quota license. When the invention influences a device that is composed of different parts, the invention value may be determined based either on the value of the entire device or on the value of the part that makes use of the invention. It should be taken into consideration what is customary in the respective industry. The second factor is the so-called share factor. As the invention is not free, there has to be a certain deduction by determining the share resulting from the employee. A deduction from the hypothetical license rate. The following aspects determine this share factor: the setting of the object of the invention, the solution of the object of the invention, and the duties and position of the employee. I will explain it a little more detailed in just a minute. Thank you.
예, 답변 감사합니다.
Thank you very much for your answer.
다음 일본의 카츠마타 판사님.
Moving on, Honorable Katsumata from Japan, the floor is yours.
In case when the employee itself practices the patent of the employee's invention, the compensation will be calculated by following formula. The reasonable compensation equals the monopoly profit multiplied the degree of contribution of the patent to monopoly profit multiplied 1 minus the degree of contribution of employer to the invention multiplied contribution rate of the inventor in case of joint inventions. Here, the monopoly profit is calculated by hypothetical license fee rate multiplied excess benefit. According to the judgment of IP High Court in 2007, which is called Canon case, the excess benefit is 40 to 50% of the benefit the employer obtained by selling the employee's invention product. And the sales of the employer includes overseas sales if the patent is registered in that country on the ground of the judgment of Supreme Court in 2006, which is called Hitachi case. As to the hypothetical license fee rate, the court usually determines the rate taking into consideration the importance of the patent for the product, validity of the patent, and ordinary rate in that specific product area. And as to the degree of contribution of the patent to monopoly profit, it is calculated based on the individual situation. In Mitsubishi Chemical case, IP High Court had taken into consideration the number of the patent or know-how included in that product and the nature of the patent, such as the product patent, process patent, or patent for usage, and also the importance of the patent. Thank you.
Thank you for your answer. Now, Judge Lee from Korea. So in cases of self-practice, the compensation is calculated by reflecting the employee's contribution and inventor's contribution. So if the product includes many inventions other than employee's invention, and if there are other factors that affect the sales, then the contribution ratio of the employee's invention should be adjusted accordingly. Going into a bit more detail, so in case of the employer's profit, it is profit generated by the invention. So such causality really limits the scope of the profit to be considered. And according to the Korean Invention Promotion Act, even if the employer does not succeed the invention, the employer is entitled to a royalty-free, non-exclusive license. So the employer's profit refers to the profit that comes from beyond the non-exclusive license. It comes from an exclusive and monopolistic license to practice the invention. So out of the total profit, we have to minus the profit that was generated due to the royalty-free, non-exclusive license. So this is included as the contribution rate of exclusivity. And such rate of exclusivity is related to the exclusive and monopolistic license. So as you can see on the slide, such factors are accounted for when calculating such rate. And according to Article 13, Paragraph 3 of the Promotion Invention Act, the employer may not own the royalty-free, non-exclusive license. In this case, then such exclusivity rate should not be factored in. It is an area that requires more research. And looking at slide 22, -1, if there is remaining patent term, then in Korea, future sales are considered. And there are 3 ways to consider the future sales. But the most popular and general practice is under the assumption that the sales as the conclusion of arguments would be the same as the sales to be expected as of the expiration date of the patent right, to add the sales generated as of the conclusion of arguments with an amount that is converted from the sales expected up to the expiration date of the patent right into the current value. There are still some arguments over this method, and the scope and the market size may all change, so we cannot determine that the sales will definitely decrease over time. So this is a still questionable method. And moving on to the next slide, when it comes to sales overseas, especially whether the sales from countries where the patent is not registered, whether it should be included, we can find 4 precedents in Korea. But the conclusion were all different, and there's no consensus in the academia. Well, since the territorial principle is applied to patent rights, the sales in countries where patent is not registered should be excluded. This is one of the opinions, but all of these precedents you can see on the slides. The ultimate country where the revenue was generated was where the patent was not registered, but still the patent was practiced, and in this case the revenue was included when calculating compensation. So it is difficult to give one clear answer from the Korean perspective. We cannot say for sure that it is a prerequisite to have patent registered or have it practiced in order to include that in sales to be considered when calculating the compensation. And in my personal view, sales from countries where patent is not registered should not blindly be excluded, but I think a territoriality principle is not directly related to employees' invention, and even if it's not registered, still exclusive and monopolistic rights can incur profit for the employer. So we should go back to the basic principle of calculating the compensation for the employee's invention and see whether there is causality between the employee's invention rights and the revenue that is generated. And regarding the employer's profit, it is very difficult to prove such profit through evidence. So when it comes to actual judicial practice, we use hypothetical royalty rate. Well, I think we should switch to profit rate when necessary, but just proving the profit itself through evidence is very difficult. So when it comes to suits in Korea, as in Japan and Germany, the hypothetical royalty right is being employed. When it comes to this issue, if it is well proved through providence, then I think the profit rate would be closely reflected. When calculating the hypothetical royal rate is shown in the slide. So please refer to the slide. Thank you.
Next, for one product, what about their other inventions, not just service invention? And also, what about the employer's marketing reputations? Those are also attributed to the sales revenue of the invention. Then how do you calculate the contribution of each party? And when the operation of the employer is important or meaningful, does he still have to pay the compensation for the employee? And if that is recognized, what are the considerations? In the case of Germany, I understand that there are some specific guidelines for this. So please limit your your answer to 2 minutes. Honorable Daifer from Germany first.
Thank you. That's a rather complex issue. As I already mentioned, you have to consider the setting of the object of the invention, the solution of the object of the invention, and the duties and position of the employee. For example, as regards the setting of the object of the invention, the share of the employee increases, the greater his initiative in setting the object and the greater his involvement in the recognition and the company's deficiencies and needs. The share of the employee shall be assessed based on a 6-point score. It is low if the employer has set him an object with immediate indication of the approach to a solution, whereas the share is high if the employee himself has set out the object outside the field of his duties. As regards the solution, the share of the employer is rather low if the solution is found with the help of considerations that are professionally familiar to him. If the solution is found on the basis of the company's activities or knowledge, and if the company supports the employee. The more independent the considerations and developments of the employees are, the higher is the factor, the share factor. As regards the duties and the position of the employee, the share of the employee decreases, the greater his insight into the production and the development of the company is according to his position, and the more it may be expected of him by virtue of his position and salary. The share is low if the employee has a leading position in the research department, for example. The share is high if the invention was made by an employee without prior qualification for the activity carried out. For example, an unskilled worker makes a great invention. And this is rather complicated, and you have to add all these numbers, these points, and then you have a table. I sent the guidelines to the conference secretariat, so it should be available for you. You add these numbers and then you get a share factor that is between 2% and 100%. Normally it's in the range of 10 to 30%. When the employer practices the invention overseas and the sales of the respective products are made there, these overseas sales are relevant for the compensation only if corresponding patents exist there. This is a rather solid German rule. I'm not aware of any academic discussion on this issue. Thank you.
예, 답변 감사합니다.
Thank you very much for your answer. And next,
판사님, 답변 부탁드리겠습니다.
Honorable Judge Katsumata from Japan.
Yes. Okay. With regard to the degree of contribution of employer to the invention, in Mitsubishi Chemical case, IP High Court determined the contribution ratio of the employer, considering the process in which the invention was made, the circumstances in which the employee ended up being involved in the said process, and the position of the invention in comparison to other inventions, the content of sales efforts made by the employer, circumstances surrounding research and development for the development of a new products, and other aspects. In recent cases, typical ratio of the contribution of employer is not less than 95%. As far as the employer practices the patent, even if the employer's operation profit is red, it does not mean the compensation is zero. The compensation is calculated based on the monopoly profit, and the monopoly profit is the excess profit multiplied by hypothetical license fee rate. Here, the excess profit does not mean operating profit, but a certain proportion, generally 40 to 50% of the sales. Therefore, the fact that the operating profit is in the red does not influence on the calculation of the compensation. In case where an employer does not file an application for patent, even in such case, as the right to obtain the patent is transferred to the employee has the right to obtain reasonable profit from the employer according to Article 35 of Patent Act. Thank you.
예, 답변 감사합니다. 다음은 한국의 이정
Moving on, Judge Jeong-ee.
복수의 발명이 포함된
Yes, if the product has various inventions or if there are factors other than the invention that generates profit, then contribution rate of the invention has been reflected actively since 2010. But the method of reflecting can be found in various ways. But the hypothetical royalty right and the contribution rate of exclusivity are reflected. This is one way. Or in other types, some other calculation factors are considered. But I personally think that when calculating the contribution of employee invention, I think it can be distinguished from the hypothetical royalty rate. So I think the contribution rate should be considered as a separate independent factor in itself. And when completing the invention, the creative contribution by the inventor is reflected as the inventor's contribution. This is another separate factor that is considered. And as you can see on the slide, these factors are considered. But if the plaintiff and defendant submits indirect evidence, the court calculates the percentage attributed to each factor. And moving on, as in Japan and Germany, the profits that employer gets from the employee's invention is what is generated by the employee's invention itself. It is not after settling all the profits and costs. This is a very clear stance taken by the Supreme Court of Korea. Well, there are some opposing voices to this stance, but as the case in Germany and Japan, only the proportion in the profits that was generated by the employee's invention should be considered, and I agree. So even if the operating profit is in the reds, the compensation should still be made. And according to Article 16 of the Promotion Invention Act, if after the assignment was made to the employer, if the employer waives to file the application for the patent, still the compensation should be paid to the inventor. So even if the application for the patent was not filed, still exclusive and monopolistic income could have been accrued by the employer, and with regards to that, the employee should be paid compensation. So the rate or ratio of how to calculate the exclusive and monopolistic profit may differ. So we need more consideration on that. Thank you.
이번에는 사용자가
And next, what if the employer does not practice the invention and gives the right to the third party? What about compensation in that case? So the employer does not practice the invention, but gave the right to the third party. How do you calculate the consideration, and how do you calculate the employer's benefit? And also, what about in the case of the cross license between the employer and the third party? In that case, any compensation needs to be paid out to the inventor, and also
사용자가 징발명을 실시하지 않고 제3자에게만 실시권을 부여한 경우
and also so depending on the license given to the third party person, how do you calculate the consideration? And in the context of the cross license, when is it obligated to pay the compensation? Honorable, we will listen to the German judge first. Honorable Diver, you're on mute. You're on mute. Please turn on your microphone.
잘 들립니다.
Yes, I have to, I think. Do you hear me? Yeah.
예,
I can be rather short on this issue. If the invention is used by granting a license, the value of the invention is equal to the net licensing income according to the guidelines, and the employee participates according to the respective share factor. So also in this case, you have to assess, to determine the share factor for this special employee, and then you give him a part of the net licensing income. As regards a cross license, if the invention is exploited by entering into a cross license or a patent pool, an attempt may be made to determine the overall advantage of the contract for the employer. That's quite difficult. Then a quota accounted for by the respective service invention shall be estimated. That's number 17 of the German guidelines. Thank you.
예, 답변 감사합니다. 네, 다음은 일본의 카츠마타 판사님.
Thank you. Now, Honorable Judge Katsumata.
Yes. Do I need to answer about the cross license too? I understand that it was the next question.
이번 질문입니다.
Oh, actually, it's included in this question. Could you please answer that question along with your answers for this question?
Yes. So, the find the employer gained the license fee of the employee's invention patent from the third parties. That license fee is deemed as the employer's profit obtained by utilizing the patent of the patentee's employee's invention. The compensation is calculated by license fee multiplied 1 minus the degree of contribution of employer to the invention. This formula will be applicable regardless of whether the employer practices the patent or not. If the employer grants a license to a third party and also self-practices that patent at the same time, the compensation calculated based on the profit from the self-practice will be added to compensation calculated based on the license fee obtained from the licensee. Thank you.
예, 답변 감사합니다.
Thank you for your answer.
카츠마타 판사님.
Judge Katsumata,
라이선스 경우에
also please give your answer about the cross license. Please.
Yes, if the employer enters into royalty-free cross-license agreement, it is very difficult to calculate the compensation, but it should be have a certain amount. IP High Court in 2012, in semiconductor integrated circuit device fabrication method case, held that the employer obtains the profits gained by being exempted from the obligation to pay the royalties that the parties should have normally paid to the counterparty by entering into a royalty-free cross-license agreement, and that it is reasonable to consider the above-mentioned profits is equivalent to the royalties that the parties should have normally received from the counterparty, which works said parties patent inventions. That's all.
예, 답변 감사합니다.
Thank you for your answer.
한국의 이정 판사님.
Moving on to the Korea's case, Judge Lee.
사용자가 제3자에게 라이선스만 준 경우에
If only the third party was licensed and there was no self-practice, the royalty income would correspond to the employer's profit. So compensation is calculated by multiplying the royalty fee with contribution rate of the employee. And if many patents were included in the patent pool, including the employee's invention, then only the portion out of the profit that was generated by the service invention should be reflected. So it's all about how you prove that portion of the profit. But if that specific invention did not generate the whole of the profit, then only the portion that was generated from the service invention should be reflected through determining the contribution ratio. And in second case, if there is both self-practice by the employer and also licensing, then both should be added and looked as a total. But whether how much of the royalty fee to be included has to be determined based on how much exclusive status was enjoyed. So if the open license policy was used, then actually the amount that will be additionally recognized will be smaller, but if not, still exclusive profit might be accrued. So I think it should be looked at case by case. I still have, we're still on 30-1. Thank you. And if self-practice and licensing to third party is not both did not happen, still compensation shall be calculated because still there might be exclusive and monopolistic profits. So still that would lead to reasonable compensation for the employee. So due to prohibiting practice of the competitors, and if some alternative substitute products were sold to accrue profit, then this is a very rare case and an exceptional case. And how to look at cross-licensing cases? Well, since the royalty-free usage of patent can be used, this would lead to saving of the royalty fee, but whether this corresponds to exclusive profit is a different question. So there are no actual judicial practices in Korea, and we look at it case by case at the court. In some cases, it did correspond to employer's profit, or after interpreting the contract, even if the license agreement led to saving of royalty fee, or even if we have to revert to the royalty calculation method, if the profit may not be proved. And the plaintiff also provided its license to the other contracting party for free, so there might be some reduction in the profit. So it really has to be looked at case by case. And if this invention was included in a pool of patents, then the proportion of how much the employee's invention takes in that whole patent pool should be calculated, but this is not an easy matter. So there is no one unified golden rule when it comes to this issue. Thank you.
답변 감사합니다.
Next. Now we are going to talk about the situation where the employer gives the patent to third party. Or if the patent becomes invalid. So in case the employer gave the patent right to the third party, how is the compensation calculated? And what if the patent itself is nullified? Is there still obligation to pay the obligation? Please limit your question, your answer to 2 limits. Honorable Dahifus from Germany first. Honorable Dahifus from Germany first.
Yes, I'm not on mute, I hope. If the employer sells the right to the service invention or the patent to the service invention, the value of these invention should be determined by reduction of the gross earnings to the net earnings. That means, in principle, that all expenses of the employer for the development of the invention after it has been completed for rendering it ready for operation, the costs of prosecution, the expenses associated with the sale, and the corresponding share of the overheads must be taken into account. That's not easy. The employer cannot invoke the lack of patentability as long as the patent has not been revoked. When the patent is revoked, the duty to pay compensation ends only after final judgment, whatever the reason for revocation. The revocation of the patent has no retroactive effect. The employee does not have to return the compensation for the time until the revocation. The respective judgment of the Federal Court of Justice, the name is Drahtinjektionseinrichtung, rather complicated, was based on the consideration that the employer possessed a preferential position as compared to his competitors as long as the patent existed. For the same reason, a licensor is not obliged to return the royalties to the licensee when the patent is declared void, according to German law. Thank you.
Thank you very much for your answer. And Honorable Katsumata from Japan.
Yes. When the employer transferred the
사용자가 그 직무 발명에 sorry.
Yes. When the employer transferred to invention to third party, the price of the patent is equivalent to the value of the invention itself. So the compensation should be calculated on the basis of the price of the patent. Next, talking about in case where there are grounds to invalidate patent rights. Basically, as far as the employer obtained the patent right and practiced it, the compensation should be paid. Nevertheless, whether there are grounds to invalidate patent rights in the light of the fairness and rule of faith. In brother industry case, IP High Court held that if the employer has used a patent right on the premise of its validity and obtained profit, but later, only after being sued, asserts that there exist grounds for invalidation of the patent right in order to avoid allocating such profit to the employee, such conduct cannot in the least be acceptable, not only in the light of the spirits of the Patent Act, but also under the doctrine of estoppel. Thank you.
Judge Katsumata, thank you. Moving on, Judge Yi from Korea. So when there is a transfer of the rights for employee invention, the transfer amount, the transfer price shall be the profit of an employer, but the employer is entitled to a royalty-free non-exclusive license. So if there the transfer amount already includes the part of the non-exclusive license. So when we are calculating compensation, the portion that corresponds to the non-exclusive license should be excluded.
특허가 무효가 되는 경우에
And when there are grounds for invalidation of the patent,
보상금에서는 특허권의
when we calculate compensation, the validity or the registration of the patent are not requirements for compensation. So if monopolistic or exclusive profit was accrued, then that suffices for compensation to be made to the inventor.
이런 부분들은
But if it was a matter of self-practice, then the validity of the patent might affect the compensation because it might affect the contribution rate of the invention. Thank you.
다음은
And next question, actually, it's an additional question to Germany and Japan. So, were there any dispute regarding how to calculate compensation? If you can answer this question, that will be great. But if not, that's okay too. Please limit your answer to 3 minutes. Honorable Daihifus, first, please.
Thank you. I can be very short on this point. There are no cases on the issue of compensation in the last years at our court. There are very few cases on the questions of Employees Inventions Act, and if there are any cases, they are normally on very special questions of law and not on compensation. The reason for this is that most cases, nearly all cases, are settled. Normally, they are just settled when between employer and employee without even going to the court or the arbitration board. And at latest, they are settled when they come to the first instance, the court of first instance, the Landgericht in Germany. And at the latest, then they are settled because parties agree that there is no sense in going to higher instances for compensation. It is too complicated and there are too many uncertainties. Thank you.
갑자기 어려운 질문을 드려서 죄송합니다.
I apologize for asking you a difficult question, but thank you for your answer.
답이 어려우시면 답변을
Is it okay?
예, 잘 들립니다.
Yes, we can hear you well. Please proceed with your answer.
Yes. With regard to the employees' invention.
네, 직무 발명 관련해서 sorry.
I hear how it's okay. With regard to employees' inventions, we have two cases which is judged by the Supreme Court. The first one is Olympus case in 2003. And the second one is Hitachi case in 2006. In Olympus case, related to the obligation of the employer, and the Hitachi case clarified that the employee can claim compensation for the patent registered in the foreign countries. And with regard to the calculation of the compensation, there are several important cases judged by IP High Court, which I have referred to so far. For example, Canon case, which held how to calculate the monopoly profit, and Mitsubishi Chemical case showed the factors taken into consideration to calculate the contribution ratio of the employer. And semiconductor integrated circuit device fabrication method case related to royalty-free cross-license agreement. And rather industry case treat a lot of issues related to the compensation. And please see my answer in reference book on the conference in detail. And you can also find in the English summary of these cases in the website of IP High Court Japan. And addition to that, I would like to introduce one most popular employee inventions case in Japan, which is called blue light emitting diode case, blue LED case. Actually, the inventor and the invention were well known in Japan, and the inventor was awarded Nobel Prize later. This case was concluded by the settlement at Tokyo High Court in 2005. In this settlement, Tokyo High Court assessed the contribution of the employer is 95%, although the court admitted the contribution of the inventor is very high. That's all.
예, 답변 감사합니다.
Thank you very much for your answer.
이번에는
And next question is about compensation payment and dispute resolution. So if you can briefly talk about the procedure and the governing rules for how to calculate compensation, that will be great. Can you have an agreement on this in advance? And what are the requirements for the compensation considered to be fair? And also, how do you resolve dispute regarding compensation calculation? Do you have many litigations about this kind of dispute? Honorable Ferram first.
Just on the, thank you. Just on the question of procedure, as a matter of patent law, there's no explicit procedure or method for solving these questions outside of formal litigation. However, there are some general law requirements before the commencement of general litigation. All the patent litigation has to come to the federal court, and before you commence a case in the federal court, you have to certify that you've been through an attempt to settle the dispute. In practice, most cases in the federal court in this area are mediated. Insofar as the parties are concerned, they are, of course, able to stipulate in their contract otherwise in relation to any mechanism for resolving their debate. Insofar as the question of how damages or compensation are to be determined in this area, damages can be compensatory, that is, the employer may be able to seek damages which will put it in the position it would have been in if the infringement had not happened, or they can, in other circumstances, take in the awarding of profits which have been made. So that's all I'd like to say. Thank you.
예, 답변 감사합니다.
Very much for your answer.
독일의 다이프.
And next, Honorable Dreyfus from Germany.
There are rules on the ascertaining of the compensation in Section 12 of Employees Inventions Act. The nature and amount of compensation shall be established by agreement within a reasonable time after the claim to a service invention. Where no agreement is concluded within a reasonable time, the employer shall set the compensation by a reasoned statement and pay in accordance with this settlement. If the employee does not agree with the setting of the compensation, he may oppose it within 2 months. If he does not oppose, the setting becomes binding. In principle, it is possible to agree in advance for calculation criteria, payment methods, and so on. However, it should be noted that the provisions of the Employees Inventions Act may not be modified by contract to the detriment of the employee, Section 22. When the parties do not come to an agreement on the specific remuneration based on such an agreement, the employer has to set the compensation, and the employee may oppose it if he does not agree. As far as the agreement in advance on a certain calculation criteria and so on are binding, he may not raise respective objections. There is nothing to prevent him, however, to argue that the agreement in advance is not binding according to Section 22. The employee may oppose the settlement of the compensation in this case, and the compensation remains pending. The employer is not authorized to set another compensation. When the parties do not come to an agreement, each of them may appeal to the Board of Arbitration at any time. They also have the right to go to the court, but only after proceedings have been held before the Arbitration Board. The proceedings before the board are not mandatory. They are terminated if the other party does not file a submission or refuses to enter the proceedings. If the other party does not refuse to enter the proceedings and files a submission, the Board of Arbitration provides the parties with a settlement proposal. The proposal shall be deemed to be accepted unless at least one of the parties objects within 1 month from its notification. And if they don't come to a settlement by this, they can go to the court. Thank you.
예, 답변 감사합니다. 다음은 일본의 카츠마타 판사님.
Moving on, Honorable Katsumata from Japan.
Yes. Even when there is a legitimate contract between the employer and the employee or the legitimate employment regulation over the employee's invention, the employee can enter a lawsuit against the employer, insisting that the compensation in accordance with the contract was not reasonable. With regard to the resolution, practically speaking, the number of mediation or arbitration over IP-related cases is quite small. For example, only a few cases a year are handled by IP Arbitration Center, which is organized by Japan Federation of Association and Japan Patent Attorneys Association. Most of disputes are resolved in internal discussion and reached private agreement, and less than 10% of disputes are brought to the court. In Japan, either mediation or arbitration is not required before taking the matter to the court. And to talk about the mediation, IP Division of Tokyo District Court and Osaka District Court started a treat IP mediation 2 years ago. And here it is quite successful in general. However, there is no case related to employees' invention so far. That's all.
예, 감사합니다.
Thank you.
다음은 한국 이정 판사님.
Now, Judge Lee from Korea. Well, in Korea, the Invention Promotion Act and the Enforcement Decree of the same act regulate the method and procedures for discussion of the compensation in Article 15 from paragraphs 2 to 5. The compensation guidelines should be written up, and when making any changes, the employee should be consulted, and if details are set, then it should be notified in writing. So, through contract or regulations, pre-invention agreement can be made, but the procedures should be followed, and the employer can set up a committee for deliberation on compensation for employees' invention, and also they can ask mediation at other employees, but this is not a necessary procedure. So only cases where the parties fail to reach agreement, it leads to litigation. But please look at the Article 15 and paragraph 6 of the Invention Promotion Act. It says that if the procedures prescribed by the article that I just mentioned are not followed, then the compensation does not fall under the scope of reasonable compensation, and thus such compensation may be demanded through litigation. And if the procedures were followed and the compensation was provided, still, if the amount of compensation does not reasonably reflect the profit of the employer and the contribution of the inventor, then still the claims can be filed. So even if the compensation was paid based on the agreement, still there could be additional claims made for additional compensation. From the industries, well, there are some criticism whether it breaches too much into the rights, but if we look at the cases in a close manner, the difference between what was paid and what is deemed to be reasonable could be fairly substantial. So such criticisms are not always has merits. So I think it's an area that needs more research. Thank you.
이번에 이제 스위스의 스와이처 법원장님 답변을 들어야 될
We were supposed to take an answer from Honorable Schweitzer from Switzerland, but due to his condition, he cannot be here with us any longer. But I can read his submitted answer. So there's no rule to be simple, to give you a simple answer. But regarding the opportunity invention, there is a code of obligations in Switzerland, and if the compensation is not considered reasonable, then that amount is not binding. So litigation can be raised, and that litigation goes to the Court of Labor Court. So that was his answer. Now, this will be the last topic of this session. So this session is about a cross-border issue regarding the choice of law. So what if there is a foreign employee of domestic company? What if there is a foreign domestic rationale working at a foreign company? And what if these kind of different nationalities are at play for invention? Then in this case, how is the law chosen to govern this case for this kind of cross-border issues? Please limit your answer to 1 minute. And first, Honorable Dreyfus in Germany, please.
Thank you. Where there is a cross-border issue in connection with the employee's invention, the legal relationship between the employee and the employer shall be determined according to the private international law for the employment relationship. According to a regulation of the European Parliament, an individual employment contract shall be governed by the law chosen by the parties in principle. To the extent that the parties have not chosen the law applicable to the contract shall be governed by the law of the country in which the employee habitually carries out his work in performance of the contract. However, as legal questions regarding a patent are concerned, the principle of territoriality prevails. Thank you.
Thank you. Now, Judge Perrin from Australia, the floor is yours.
Thank you very much. Well, in this situation, the first step is to determine the proper law of the employment contract. That involves a test of asking which jurisdiction it has the closest and most real connection with. Typically, the matters which are taken into account in answering that question are the location of the parties, the place of the contract, the place where the contract is performed, and sometimes the location of the assets. Where questions of employment law are concerned, as here, the first and third of those matters, that is the location of the parties and the place of performance, are particularly important. If you had, for example, a contract between a Korean company and a Korean individual, which involved the individual creating an invention, which was then to be made the subject of an application for an Australian patent, it would be reasonably clear that the proper law of that contract would be Korean law. The Australian court would therefore determine the employment issues by reference to Korean law. Insofar as remedies are concerned, the remedies which would be applied would be the remedies afforded by the local court, in this case the Australian court. That makes particular sense where one is talking about an Australian patent and therefore remedies underneath that patent statute. So thank you.
Thank you for your answer. Moving on, Judge Katsumata from Japan, the floor is yours.
Yes, the lawsuit about ownership of the employee's invention should be governed by the law of the country where the patent right to be registered in light of the principle of territoriality for the patent right, according to the judgment of the Supreme Court in Japan. In Hitachi case, On the other hand, as far as the lawsuit claiming compensation, at first, the applicable law is determined by the party's intention. Thus, if there is any agreement, even implicit, between the employee and the employer, the applicable law should be determined on the basis of the agreement. So, if there is a written agreement about the applicable law, the court should choose the applicable law in accordance with the agreement. And if there is no written agreement regarding the applicable law, the court will most likely presume that there is the implicit agreement between the agreement concerning the compensation should be governed by the law of the country where the company places or the employee worked at. Thank you.
예. 카츠마타 판사님 답변 감사합니다.
Judge Katsumata, thank you for your answer. And Judge Kim for Korea is the next panel, but he will also read the answer for Switzerland together. Thank you. So finally, we are at our last question, so please bear with us. So President Schweitzer sent his written response, so I cannot emulate his voice, but I will summarize his answer and quickly deliver it. There are many similarities with the Korean legislative structure. So in the slide on the top, very top, you can see the summary for Switzerland. So if there if there is agreement between employee and employer regarding choice of law, then that would be upheld. If there is no such agreement, then the location where the employee habitually performs their work will be the country of the choice of law. And if the employee does not habitually perform work in one place, then it is the law of the state of the establishment, and if that is absent, then the domicile or habitual residence of the employer will be referred. So the Federal Act on Private International Law, PILA, which corresponds to the Act on Private International Law, is set in place. So if there is agreement, that comes first. If not, then the contract relationships that is determined in the agreement will be respected. Korea has a very similar case. We have some time, and since we are holding this conference here in Korea, the Supreme Court of Korea's precedents will be looked at. I hope interpreters will be able to handle this. So, the Supreme Court of Korea, when it comes to employees' invention, the ownership or succession or practice or the claim for compensation should be determined based on the contract between the employer and employee. So all the rights and obligations that arise due to employee invention, even if there are cross-border elements, well, the establishment of the patent right, validity and invalidity is not in relation here. So based on territoriality principle, the Article 24 of the Act on Private International Law should be applied in this case. The right to acquire patents would rely on the employment relations, and the rights all arise out of the same employee's invention. So, for the stability of the act, the country of employment should present a uniform set of laws to govern such matters. The governing law for the employment contract should be looked at for dealing with such matters according to the Act on Private International Law. This was the ruling of Supreme Court of Korea. So in sum, when it comes to employees' invention, if there is explicit or implicit agreement between the parties, that should be followed. If there is no such agreement, then the location where the employee habitually performs duties should be looked at. If that is not the case, then the business place that has hired the employee should be the country for the governing law. That was the case for Korea. Thank you. Thank you for your answer.
이것으로 이번 세션에서 준비한 질문은 모두
So with this, we've covered all the questions we prepared for this session. Before concluding this session, I'd like to ask all our panelists to give us one final comment. Please limit your comment to 1 minute. Maybe we can start with Honorable Young-gi Kim from Korea.
What a long session, but I think it was really interesting session to all of us. As a judge in IP field, I'm sure that our active interaction over diverse topics today will tremendously contribute to the development of the legal process or legal procedures, as well as pertinent laws for fair resolution of disputes on employee inventions issues. Personally, I feel very sorry for not having all the panels today right here and for not being able to share delicious Korean hot food in this very beautiful fall and maybe watching Squid Game all together. Certainly, I will look forward to the next time. Thank you.
예, 다음 독일의 다이프스 판사님 말씀 부탁드리겠습니다.
Judge Dreyfus from Germany. Could you have your last words, please?
Yes, thank you. Thank you for the invitation to the conference and the meticulous preparation. I remember well my coming to Seoul in 2016, and I was very touched by the hospitality of the Korean IP court and all of you have taken part. In my eyes, the German law on employees' invention is rather complicated, but it has proved its worth. There are very few lawsuits in this issue. Most cases are settled. The rules are widely accepted and a valuable contribution to a prosperous cooperation of employers and employees. Thank you.
예, 감사합니다.
Thank you.
미국의 기스텝 법무장님의
And Judge Gilstrip's remarks will be watched in this video.
Again, it's been a privilege and an honor to be a participant in this conference, even though it's been done virtually. And I look forward to the next opportunity I'll have to be a part of something like this in the future. Thank you very much.
Next,
카츠마타 판사님.
Judge Katsumata from Japan. Your last remarks, please.
Yes, thank you for providing an opportunity to explain our practice and the situation in Japan. It was my pleasure to attend such an interesting and fruitful session. And thank you, and see you later.
감사합니다.
Thank you. And Judge Param from Australia, your last remarks, please.
Thank you very much to the Patent Court for the invitation to speak at this conference, and my compliments on the high degree of organisation which has gone into it. From my perspective, what has been interesting is the contrast between those systems which deal with the employment situation under the rubric of general law principles, as opposed to those jurisdictions which deal with it in a particular fashion. I was particularly interested in one of those jurisdictions, the German jurisdiction. There seems to be much less litigation, whereas under our system, where we have no specific rules, we seem to have quite a lot of litigation in this category. So that's certainly, from an Australian perspective, food for thought. But again, thank you very much for this opportunity for participating. Thank you.
말씀 감사합니다.
Thank you for your remarks. And Judge Lee from Korea, your last remarks, please. Yes, so through this conference, we were able to look at the system surrounding employees' invention. thank you all participants who joined online and from various time zones, and all of the judges who have sent in valuable materials in advance. And I would like to thank the host of this event, which is the Patent Court of Korea. Thank you for inviting me. I hope COVID-19 will be put to an end swiftly so that we will able to invite all of the panelists here on site and we can have a more in-depth discussion. Thank you.
변호사님 말씀 감사합니다.
Thank you.
시간이 원래 예정된 시간은 조금
We went 10 minutes. We are actually 10 minutes early than the time that is allotted to us. Actually, Judge E already said everything that I wanted to say, so
그렇습니다만
yes, I will try not to repeat what she already said. But through this session,
직무 관련에 관한 각국의 입법 내
we looked at how the employee's invention is governed under the statutes and the judicial practices of different countries. And Japan and Korea have similar systems in place, but still, I think the actual judicial practices have their differences. Well, today we only looked at the general aspects, but the details can be found in the reference book. And if you look at the reference book closely, then you will be able to find various differences among the countries. And we weren't able to hear everything in full about all of the issues that we wanted to cover, but please refer to the reference book for details. Thank you for staying attentive, and thank you all panelists for introducing your precedents and statutes regarding employees' invention. Thank you. I hope that we will put COVID-19 under control so that we can invite all of the panelists to Korea. And thank you for staying attentive during this lengthy conference for all of the participants online and on site. And I would like to express special gratitude to President Schweitzer from Switzerland who joined despite his conditions. So this brings us to the close of session 5, and after lunch we will be holding a moot arbitration, so please stay tuned. Thank you.
감사합니다. 발표를 진행해 주신 연사분들과 좌장이신 김동규 고등법원
I'd like to thank the moderator, Judge Kim, and all of the panelists. So from 2 p.m. after lunch break, we will have moot arbitration with arbitrators from 3 countries, Korea and Japan and Germany, so please stay tuned. Well, one announcement to all of our participants on site: if you just stay in your seats, then lunch will be delivered to you, so I hope you enjoy your lunch. In order to prevent spread of COVID-19, please have your lunch at your designated seats only. Thank you.
이제 시간이 된 것 같습니다.
I think it's time to begin.
이제 특허 예, 안녕하십니까. 정영 판사입니다.
Good afternoon. I am Judge Jung Hee-young.
특허법원 콘퍼런스의 마지막
The very last session of the IIPCC will be the moot arbitration.
우선 지금 제가 사건의 개요를 먼저
I will
말씀드리겠습니다.
first explain the case that we will deal with.
모의 중재 시나리오 PPT 좀 띄워주시기 바랍니다.
Please put on the slides. Thank you.
사건의 개요입니다.
So this is the case overview.
본 모의 중재 사건의 신청인 본안 사건
The
1990년부터
plaintiff
비장치를 제조 또는 판매해온 회사입니다.
is a company that has been manufacturing
본안 사건 피고는 2005년 신청인 회사의 연구원으로 입사하여 근무하다가
device B from the 1990s, and the
문제의 비장치
defendant is the previous researcher at this company who has worked since 2005. So
공정이라고 하겠습니다.
the component at issue here is component A, which is made during the earlier process, and
공정 이렇게 두 가지 공정.
device B is manufactured by also a later process where component A is equipped in device B. And regarding the essential component A,
10개 정도 종류의 기존
before this invention at issue, there were about a dozen or more than 10
발명자들 중 한
A components that were in the market.
비장치에 장착되었던 핵심 부품인 기존
So
A
one of the
부품 대신에
inventors
새롭게 사용 가능한
have invented a new component A, which will be referred to as component AA from now on. And this case is about that component AA and the manufacturing process of that component. So the researcher has worked at the company since 2005.
연구직원 3명이 더 있었습니다.
And in the research team, there were 3 more researchers.
당시 피신청인 회사의 기존
After joining the defendant's company,
부품을 대체할 만한 새로운
the research team has
현재 진행하는 중이었고
actually the research team originally at the company has been conducting research to replace component A for 3 years, and to identify the problem and resolve the problem,
리스트 작성을
they have partially completed a list that needed to be worked on.
피신청인은 그 연구팀과 함께
And
2011년
the plaintiff has joined that
제조 방법에
a
관한
team and completed the invention in 2011 with regards to component AA,
발명에 대해
and the research team has transferred completely the right to acquire patents for that invention, and the invention
13년에
was registered under the Korean patent system, and was also registered. The patent was also registered in country D in 2014. Now, this is the relationship of use of the inventions. The defendant company, starting from 2012, produced a B device equipped with AA component in plants in Korea and country G. The B device that was produced were sold in Korea, country D, and also in country H, where its patent was not registered. And you can find the details in the reference book. And the defendant company
발명에 대한 실시권도 허락하였습니다.
has also entered licensing contracts
2015년에
in 2015 with company Queen.
비장치 관련
They
특허법이
entered a cross license
크로스 라이선스를 부여하는
where they granted each other all patent rights and licenses with regards to device B, and Queen paid the defendant company $500,000 500 million won. And in 2016, with the Princess Company, the defendant actually granted the Princess Company a worldwide non-exclusive license for 10 patents that it held related to device B, and the defendant followed its regulations with regards to compensation and paid the plaintiff $10,750 as compensation. After leaving the company in 2020, the previous researcher, the inventor, filed a suit against the defendant company at the Seoul Central District Court in 2020, and they decided to forward this case to the panel judges of this conference, IPCC, in 2021. And at the issue for this case, whether the compensation paid to the plaintiff was fair, and how to calculate the profit that comes from practicing, self-practicing and licensing this invention, and calculation of the exclusivity contribution rate will be discussed. Now let me introduce the counsel for defendant and plaintiff. Please give them a round of applause.
그리고 모의 중재
And now, this is the tribunal for the arbitration made of judges from Korea, Japan, and Germany, and they are going to join virtually from Germany and Japan.
안녕하십니까. 저는 이번에
Hello, everyone. So, among the tribunal made of 3 arbitrators, I will be the chair arbitrator, Judge Lee Ki-hyung of the Patent Court, and we will refer to ourselves as arbitrators. So, based on the agreement on arbitration by the parties, this case was forwarded to our IPCC panel, and I would like to introduce our arbitrators, Judge Herman Dreyfus from Germany, and also from the IP High Court of Japan, Honorable Judge Kumiko Katsumata. They were also panelists who shared their valuable insights in session 5. And as you can see from their bios, they are the best and top experts in the field. So they have very deep insights about this matter. Before we jump into the arbitration itself, as you are aware, arbitration requires high level of expertise and independence, just like the litigation court, but the terminology, procedures, makeup of the tribunal, and the element of private decisions can greatly affect this particular type of dispute resolution. The arbitration site was decided as Daejeon in South Korea. It will follow the Korean arbitration law and the Invention Promotion Act, and we will use Korean and English as the language. Well, we are seeing increasing cases about the patent, and this topic is very complex, but I'm sure if you follow closely, then you will be able to understand the details of the case. Invention, the decision of compensation on employees' invention needs to take into consideration many factors, and there are many still gaps in the jurisprudence with regards to this issue. But please keep in mind what you heard in session 5 to follow this case. And the award of today's panel are based on personal opinions of us arbitrators, and the issues are all hypothetical, which further needs to be addressed. So please take this as an academic discussion that will contribute to future progress in the area. And please look at page 358 in the reference book for the details of the arbitration procedures. So since we are going to deal with fair compensation for employee invention, we will first listen to arguments from both sides, and we will ask questions that we might have, and then each arbitrator will take time to deliver our opinions and deliver the final award. And the panel made of 3 arbitrators will follow the majority rule to reach the final award, and the award has the same force as the final decision of the court, and only a revocation suit can be filed against the award, which has to be filed within 3 months. Of course, this is a moot arbitration, so such procedures will not be followed through, but still, I just wanted to explain it. And so now I would like to introduce the counsel, but arbitrate. First, I will use both claimant and plaintiff as with regards to terminology. So first, attorney Chun Eung-jun, second, attorney In Chol-gun, and third, attorney Park Sung-soo for the plaintiff side. And then now for the defendant side, attorney Kim Bu-han, attorney Gu Min-seung, attorney Kwon Lee-sun, and attorney Yeom Ho-jun. These are the counsel for the 2 sides, and our reference book also lists the name of all of the other professionals who have helped us prepare this arbitration. Now, let's jump into the case. The case number is 2021 Arbitration One, and it was filed for the compensation for employment invention. We will now proceed with oral proceedings. I have to note one thing that is not in the reference book. The patent term ends in 2031, but the plaintiff only makes demand for compensation until 2020. And since there was no special mention in the written brief by the defendants, so we just decided to take that as a fact and rule on that. And the exchange rate, the dollar to won exchange rate is $1 to 1,167 won as of October 26th of 2021.
So this, just a pause. Please limit your presentation to 20 minutes. Go ahead. So this is our claim. The first, the defendant shall pay the plaintiff 5,407 million plus interest thereon at the rate of 12% per annum from the date, and also the cost of litigation shall be borne by the defendant, and the provisional execution application we'd like to withdraw it, and the B device was invented by the plaintiff in the course of working at the company, and the existing A component was going to be replaced by device B, and this invention is now registered as patent number 5 million, and R1, R2, and R3 there are multiple inventors, And also, the Korean patent takes priority in country D, but also registered as a patent in country D under the same invention name and the same inventor's name. This is the business circumstances. So before the plaintiff completed this component, the King company was the vendor, and so this company had to pay 5% of license to King before component B was completed. There were 5 companies who were able to produce device B. Goes to show how difficult it is to invent this device. And also, as this AA component is made, device G is made in Korea and other factories, and that's sold globally at estimated $1.1 billion. And AA component was used before component B was available. So the VSB's patent belongs to the defendant. And also, B production was reduced, and the overall production cost was reduced because of device B. And Princess has the 10 patent rights and the licenses, and the license cost, the royalty is about 10% of the revenue. And with the Queen B, with the AA and utility mode and all the licenses belong to Princess Company. And let me skip the details. You can refer to that. And the profit was divided among the 4 inventors, and defendant paid only $100,000 to the plaintiff as compensation. According to the governing law, the employee compensation for the invention should be fair. But the compensation was not fair because it does not reflect the feedback from the employee. So the compensation cannot be considered reasonable. And according to the defendant's policy on compensation, the inventor was not given any feedback about the compensation amount. But the compensation should be a fair amount. But there were performance compensation and disposal compensation, and they are all determined by the employer. So the employer's benefit is a key consideration. So if that benefit goes beyond a certain amount, then the compensation should also be larger. But that was not reflected in the compensation amount. And also, the compensation policy of the defendant covers only 7 years after the patent. But the patent term lasts about 20 years. So that is also unreasonable. And within a certain time period, if there was no application, then the inventor is deprived of the right to claim the compensation. That is also not reasonable. So, plaintiff has not received a fair amount of compensation given these circumstances. Let me explain about the compensation on page 10. So if you look at this, look at the profit and contribution, and each party's contribution for the joint invention. And also if you look at the profit, if you also look at the revenue, and we look at the hypothetical royalty. So this is how this is supposed to be calculated. On slide 13, so this is about the device B. So basically the patent is both in Korea and the country D. So based on this patent, revenues occurring in these countries are considered as benefit of this company. But as you can see at this table, there is a production in D and G. Here, there's no patent registration. So in this case, what about the revenue of this case? We need to think about that, whether that should be recognized as a revenue basis for the compensation. So it's produced in country G and sold in D, and we believe that these are closely related. So this country G revenue should also be basis for the compensation level. And for that, you can refer to the Supreme Court decision 2014 DA as written here. And also, if you look at the patent court decision, year 2020, now 1155 as well. So employees' invention should be considered here when calculating the compensation based on the revenue in the non-patent registration country. So this revenue in country G, so in country H, what about causality? If certain things didn't happen, we consider other things that happened. So that is the hypothesis. So here we need to think about the hypothesis where the inventor did not invent this device. So in the absence of this device, this company would have continued to pay 5% of a royalty rate to other company, other vendor, Queen. But with this invention, so without this invention, the company would have continued to pay that royalty to Queen. So the production in G country and sales in H country would not have happened without this present invention. And second fact is the defendant had a limited license, and also with this limited license, it still has control for the distribution and sales of this product. So even though the license is limited, still the defendant company has control. And also, if you look at, there are 5 competitors regarding this device in countries in D and other countries as well. But this patent, this invention patented in Korea is also registered in country D as well. So because of the country D patent registration, these 2 companies are also within the scope of this patent. So it cannot go beyond the exclusive license. So given that, the device B, even though the revenue that occurred, in the non-patent registered country, but that revenue should be considered for the basis of the compensation as well. And we also looked at the self-practice as well. Defendant has now 2 licenses. So we need to look at whether that, but based on the exclusivity, we can consider all the revenue as the benefit of the defendant company. And also, much of these components, much of the processes that go into this device are later processed. So essentially, we believe that this device is subject to a licensing. And also for Queen Company, there's a license agreement as well, but that was a royalty-free license. But but that is on the condition of liability exemption for infringement. So we consider that as actually non-royalty-free license. And also we need to think about the contribution rate of the invention. And we calculated the contribution rate. We looked at the hypothetical royalty rate. But given that we can use the hypothetical royalty rate, we did not feel the need to calculate specifically each inventor's contribution rate. Slide 19. So we do not believe the contribution ratio need to be considered specifically separately, but the contribution ratio of the invention at issue is 100%, because the other 9 patents in the later stage, they are all replaceable. And also, their contribution is only 2 compared to alternative technologies. And also, the production cost of device D decreased from 20 to 15% of the sales. And the hypothetical royalty rate is another issue here. And we need to see if the license has been granted in the past, but there was no such license granted in the past. Then we need to look at the impact from this invention on the market status, the market share, sales growth, etc. On page 21, but in this case, in present case, there were 2 royalties that could be considered. First, the defendant paid a royalty to company King. In this case, the defendant paid a license fee to company King in country D, but that was kind of replaceable. So when the defendant gives a license to a similar license to others, the same rate can be applicable. And case 2 is that the defendant has received a royalty from Princess Company. So if we move on to the next page. So regarding Princess Company, the royalty rate was quite high, but that was for 10 patents. So we needed, so it was very difficult to kind of separate royalty rate for each patent. But since we are talking about 10 patents as a whole, and also we do not believe that 9 patents out of that 10 patents are that valuable. So we cannot equally divide the given royalty rate among 10 patents. So as such, we believe that 5% is it's the right amount for the hypothetical royalty rate. And also, do we need to consider the average royalty rate of the same technical field, which is 30%? So when there were precedents regarding royalty rate, we could refer that as a reference, but that is not the case here. So we do not believe that we can strictly abide by the 3% average. And also the contribution rate of exclusivity as well. So defendants had excess profit thanks to this invention, so that needs to be recognized as well. But there's no objective data to support that. So given that, The contribution rate of exclusivity can be determined by looking at what has been the impact on this company's market share thanks to this device. Given that, after this invention was made and the patent was registered and the product was were marketed and sold, the market share of this company grew to 55%. So we believe that the contribution rate of exclusivity of this invention is approximately 45%. And regarding the contribution rate of exclusivity, and when this invention is practiced by others, we believe that the contribution rate of exclusivity should be 100%. But we also need to see if this practice by others has any negative impact on the defendant. But in our view, the other parties practicing this invention is at a very negligible amount. So for self-practice, we do not see the exclusive profit. And inventor's contribution. So we believe that the inventor's contribution is 70%. The inventor already has a high academic degree of PhD, but this company did not have enough basic research until our plaintiff came to work. So we believe that the inventor's contribution is 70%. And last, there are 4 co-inventors to this invention. So we are going to claim 25% given that. So our conclusion is that the defendant is obligated to pay the plaintiff $5.4 billion. And excluding the already provided $10,750 in the U.S., there's the remaining outstanding amount that needs to be paid to the plaintiff. With this, I'd like to conclude my presentation. Thank you.
No, thank you, Plaintiff's Counsel. Now it's the defendant side's turn for your oral proceeding. So we will start our response. Well, we have to look at the fairness of the regulations surrounding the compensation. So in order to look at whether it was reasonable compensation, we have to look at whether the procedure surrounding stipulation of the standards and whether provision was fair and whether the circumstances surrounding hearing employee opinions was fair. So first, in the process of stipulation of compensation standards, defendant engaged in negotiations and heard opinions from employees. And second, the plaintiff was included in the employees who were able to access the published compensation regulations. And third, with regards to employee opinion hearing, there was the internal process where if deliberation was necessary for determining the standards, the employees can join, and even after the compensation was set, the plaintiff had the choice to raise objections. So, given the 3 circumstances, the compensation was provided following the reasonable procedures that is required under the Promotion Invention Act. So, there is no additional compensation that is necessary. And also, with regards to profits from the defendant's sale. Well, the argument with regards to sales and the invention's contribution rate. I'll look at how the plaintiff's arguments are unreasonable. So first, I'll look at the unreasonableness of their argument with regards to sales. The sales in the countries where patent is not registered, the sales in such countries, should that be included in the whole of the profits? Well, jumping to the conclusion, the defendant thinks that identical and similar product sales being excluded under an exclusive status that is not valid in the countries where the patent is not registered, so sales from such countries should not be included in calculating the compensation. Going into the detail, the defendant thinks that, well, we have opinions with regards to the Supreme Court decisions cited by the plaintiff from 2017 and another from 2021. With regards to the Supreme Court decision, states that the sales from country where patent is not registered should be included because it can be deemed that the patent was practiced in Korea. That is the biggest ground for such decision, but I don't think that just simply the fact that such practice could have taken place should be the standard, because when it comes to invention, what it matters is what the employer is gaining. If it did not lead to actual sales, then we should think that there wasn't actual profit. Based on this Supreme Court decision, it says that while it should be included in calculation, but it should be considered as a factor to reduce the contribution rate or of the exclusivity. If so, then sales in country where patent is not registered, then contribution of exclusivity in that case would be almost zero. Because if we look at the ruling, from 2017, it shows that if banning competitors from practicing the patented employee's invention, if that led to increase in sales, that is when this is applicable. So in country H, the patent is not registered, so the patent right over the employee's invention did not prohibit competitors from practicing such an invention. Therefore, contribution rate of exclusivity in such case. So even if we do include sales from country H, due to the factor of contribution of exclusivity, it will be reduced to zero in the end, anyways. And in the country where the patent was registered, sales in such countries should be considered. If we look at sales in country H that was produced in country G, so even the country where production took place, the patent was not registered. So the Supreme Court case is not applicable to this case. And I will explain about the unreasonableness of the argument about the contribution of the invention. Plaintiff said that the contribution ratio is 100%. But out of the whole production process, this is only one component, and the process technology thereof. There are 10 inventions used for device B. And with regards to other 9 patents, the plaintiff's argument totally just neglects the other 9. Even if we factor in all other factors, the argument that the invention's contribution ratio is 100% would have no grounds. Now, I will talk about the unreasonableness of the plaintiff's argument on the hypothetical royalty rate. So the King's patent can replace this invention. So the plaintiff argues that the royalty rate for the King's company component, which was 5%, should be applied here, but royalty rate should take into consideration the actual circumstances of when the royalty rate was decided. At that time, there were only 5 countries that can manufacture this, and they did not engage in any licensing agreements further. So the defendant company had a less powerful position in the negotiation vis-a-vis the King company. But after this invention, now there are 6 companies, so the royalty rate should be reduced now. And at that time, they thought that the royalty rate should increase because the sales they thought would increase, but the trends shifted starting from 2017. And with regards to the licensing agreement and the royalty rate from Princess Company, actually the royalty rate was for the total package of 10 patents, so that royalty rate is not directly applicable for this case. So it is the defendant's position that the average rate in the industry should be applied for the royalty rate of this component. And the precedents here show that the average royalty rate is usually what is used to determine the royalty rate. So the average rate of 3% should be used as the hypothetical royalty rate for this component. And it is impossible to actually set it as higher than 2% if we consider all of the circumstances. And out of all of the components used for device B, this is just one component. So the contracts were with the Princess Company where royalty rate was set at 12% for 10 components, it can't be directly applied because although we don't divide equally among the 10 patents, still it should be considered. And the defendant made investment and efforts for the sales of device B, and after 2017, the sales for device B has been decreasing, and the validity period will come to an end soon for component A, which will increase the number of alternative technology. And if we look at the Korean cases, the hypothetical rate usually is somewhere between 2 to 3%. There was one case where there was 5% royalty rate, but this was a pharmaceutical invention, and 5% was the average rate of that industry, so that's why this was cited. So in our case, 3% should be applied, but given all of the other circumstances, 2% of royalty rate should be the maximum reasonable hypothetical royalty rate. Also, with regards to arguments, plaintiff's argument regarding exclusive rights contribution ratio, well, the market share at the time was taken into consideration, but it's a rather arbitrary argument because 2017 was when market share was at its peak. And even if we follow their logic, only 35% was increased. And from 2017 and now, the sales has greatly decreased starting from 2017. And from this, we can tell that this component's inventions contribution to the sales of device B was not significant. The actually defendant's foothold in the market and its technical prowess have greatly contributed to the sales also. So the actual exclusivity contribution rate is not as high as plaintiff is arguing, and we should also take into consideration that with King and Princess Company, the defendant did enter licensing agreements, so exclusivity was undermined. So the royalty rate and exclusivity rate contribution are all included in calculation of the compensation. But since the defendant's exclusive status is undermined due to licensing agreements, this should be factored in. And lastly, although we think that sales from countries where patent is not registered, although we think that it should be excluded, it would still be greatly reduced due to the exclusivity rate. And with regards to defendants' royalty profits out of licensing agreement with third parties, the employer's profit generated from self-practice and royalty income from licensing agreements, in such cases, the employer's profit is from a royalty-free, non-exclusive license, which is not an exclusive profit. So when we calculate the employer's profit, the profit from self-practice, if that is considered, then separately, if we also factor in royalty income from Princess and King, then it would lead to an exaggeration of the employer's profit. It was mentioned, but plaintiff is almost arguing that the other 9 patents in the later process are not valuable, but in fact, the later process related 9 patents have the effect of reducing production cost by 2% compared to all of the other comparable technologies. Therefore, through the licensing agreement among the invention that was licensed out to Princess, we should consider the value of the 9 patents. So even if the $100,000 of royalty income from Princess is considered as employer's profit, among the royalty income from Princess, the income thereof will only be $100,000. And about the licensing agreement with Queen Company, well, this is actually the contract. So, among the parties, if a written agreement was made, if the language is clear and there are no special circumstances, that content should be respected. That is what the Supreme Court of Korea holds. The licensing agreement between defendant and Queen, it is royalty-free, and the $500 million that was paid to the defendant is for the exemption of any infringement of patent. It is very clearly written. So the plaintiff's interpretation goes against what is written in the contract and is therefore unjust, and the defendant's income coming out of this contract is not a royalty, but it is merely for the exemption of any patent infringement liability. And it is a cross-licensing agreement. Through the cross-licensing agreement, it is difficult to say that the plaintiff only gained from the contract. The defendant was also able to practice the patent of Queen. And between the defendant and the Queen, the subject of licensing includes all future patents that the two might retain until 2025. So the plaintiff argument is unreasonable in that it does not take this fact into consideration. The 9 patents are valuable. The 9 patents that is related to the later process, but I already explained, so I will skip this part. For the production of device B, we don't need Queen's authorization, but just because Queen did not file for such infringement, it cannot prove that any patent of company Queen was not used in this process. So the plaintiff's argument does not have grounds. None of the plaintiff's arguments have grounds, and even if the 500 million won that was paid from Queen, even if that is with regards to the patent, but the amount of profit would be a lot lower than what the plaintiff is arguing. Now, the contribution ratio of the inventor is the entirety minus the employer's contribution, which would include any support or investment from the employer. So looking at we have to look at all the process of completing the invention and registering the patent right for the invention. The employer spent huge amount of investment for the research and development of the invention. And if we look at the process of registering the patent, if the employer had to spend a lot of money and time and effort for registration, then the contribution rate would consider to be very high. And depending on the manner in which the employer practices the patent, the actual profit would greatly vary. To look at the contribution ratio of the employer in this case, it is almost $0.9 million. And even before the plaintiff joined the research team at the defendant company, relevant research has been going on for 3 years. So the defendant company already had know-how and technology with regards to this invention, and a lot of the employer's resources were put in to this invention. Also, the defendant had to spend a lot of resources to engage a professional firm to get this patent registered. And the defendant had to move through the commercialization procedures and actually manufacture this invention. The practicing ability and the licensing ability was what achieved all the licensing agreements with the other companies. If we take into consideration these facts, the contribution rate of employer should be 95%. And with regards to the contribution rate among the joint inventors, it will be 1/4. This would be the end of our argument. Thank you.
So we've listened to both sides' presentations. So for each point, each party made a very compelling case. So this is not easy to come to a conclusion. But now we will take questions from the arbitrators. So arbitrators, do you have any questions for either party?
Oh, I don't have any questions at the moment. Thank you.
Thank you. Honorable Katsumata.
Yes, I have 2 questions. The first question is, I'd like to ask both defendant and plaintiff. The question is, with regard to the opinion hearing to the employee, did the defendant hear the plaintiff's opinion about the amount of compensation? If the answer is yes, what did the defendant, when and what did the defendant hear? And the plaintiff's opinion was, what was the plaintiff's opinion?
일단 답을 하시겠습니까? 예, 시나리오에는
per the scenario, so the defendant does not take the, so there is no indication that the defendant takes opinions, listen to the opinions of the plaintiff. But even if that is the case, regarding if the need arises, there is a possibility that the employee can speak up, and also even after the compensation was fixed, there was actually grace period where the plaintiff was able to submit their opinion. And second question.
Honorable Katsumata, can you pose your second question?
Yes, and my second question is, I'd like to ask the defendant. The second question is regard to the licensing agreement with Queen Company. I wonder why the defendant doesn't pay money to Queen Company. Could you explain the reason and what the parties took into consideration when they agreed the conditions and the amount of money?
네, 답변 드리도록 하겠습니다. 답변에 앞서서 가능하다면 우리 그 PPT 17면을
Before answering the question, please, can you put up slide 17 for the organizers? This is a request for the organizers. Yes, I'll start answering while in the meanwhile.
퀸사의 라이센스 계약
The licensing with the Queen Company
감사합니다. 다음과 같습니다. 여기
is, as you can see on the slide.
상황에서 실시료는
So
무상인 크로스
in
라이센스
3, it's a royalty-free cross-licensing, and for the parties, it is for the exemption of patent infringement for both sides. So in return for exemption of such liability, 500 million won was paid. That is very clearly stated in this licensing agreement. Therefore, so this is for the exemption of any liability for patent infringement, and how this specific amount was set comprehensively takes into account various factors, so I can't explain everything in detail here. Thank you. Yes, so I have also one question.
So regarding contribution, so the employer, they also did all the professional service investment, for example, assessment of the invention value and patent registration. Given that, what is the employer's contribution in your view? Once the invention is complete, then we believe that that kind of contribution by the employer needs to be recognized, of course, but the same principle can be applied in a negative way. For example, the patent registration is done only in Korea and in D country, but the patent registration was not done in other countries that are at issue here. So we also need to think about employers' responsibility in that regard as well. So if there's no further question here, we will close the Q&A session from the arbitrators. So the plaintiff's final closing remarks. Final closing remarks. So for the inventor needs to receive a fair compensation, because that will benefit the society overall, because that will encourage further inventions. So that is why employees' invention needs to be fairly compensated according to the law. And so as long as the employer enjoys a benefit from that invention, and And as long as there is a nexus between the employee's contribution to the invention, and irrespective of whether that invention is registered as a patent in the selling country or not, that all should be considered as the contribution of the inventor. Then how fairly share the profit among the employer and the inventor? That is an important issue here. And I believe that the honorable arbitrators will come to reasonable judgment on that. But we also need to think about the positive impact on the employer's market share thanks to this invention, and we believe that the plaintiffs is entitled to a much fair share of the profit than what he currently received.
And now for the defendant side. The compensation's reasonableness will be reviewed. The standards for the compensation, opinion hearing process, and the stipulation provision of compensation all followed the fair procedures. Therefore, the fair, reasonable compensation was paid, and there is no additional amount to be paid. And with regards to how it will affect the society, the R&D costs was very heavy for the part of the defendant, and even before the plaintiff joined the company, the research has been already ongoing. And even before, yes, the plaintiff joined the company already used a lot of material and human resources. And even after the invention, a lot of effort was necessary to acquire the patent. The practicing ability and the licensing ability of the defendant greatly contributed to the sales, so the defendant's contribution ratio is pretty high in this case. And the sales in countries where patent is not registered should not be included in calculating the compensation, since there is no exclusivity. And even if it is included, the contribution of exclusivity is almost 0%. And the invention's contribution ratio is low because it is one of the 10 patents that are used for the device B, so it should be much lowered. And about calculating the compensation, the patents with relation to component A, there were only 5 companies who retained relevant rights at the time, and there were no further licensing agreements made. But since then, the circumstances greatly changed because there is one more company that can manufacture. So it is no longer a highly monopolized market among just 5 companies anymore. And at the time, it was expected that the sales would rise, but from 2017, the sales took a downturn. Therefore, rather than the patent, the sales, it was largely due to the market significance of the defendant, rather than simply this patent. Just one last comment. The plaintiff has mentioned in their final argument the purpose of the employee invention system. If there is a specific need, then a reasonable compensation should be made for the invention, but at the same time, it should not be overestimated. When it comes to practicing and licensing of patent, I would like to emphasize this one point. When we look at profits from self-practice by the defendant, including the royalty rate from Princess and Queen, adding that to the profit, this would bloat the profits for the employer. Thank you.
Thank you all. So yes, both parties are very fierce in their presentation. Excuse me. the defendant actually took more time, so can we add one more point to our final comment? So here, but the revenue in the country where the patent is not registered, should it be considered as a basis for the compensation? That is a key issue here. So basically, if there is relevance can be established, then that should be considered. That is the Supreme Court ruling in Korea. Of course, as the defendant mentioned, so the product, when the product is partially produced in Korea, where the patent is registered, or if it is produced in other countries and then brought back to Korea. So actually, that was the case for that Supreme Court ruling. So that was slight difference from this case. But still, even if there's a no patent registration in other markets, it is clear that this employee's invention made a contribution to the sales that occurred in the country where no patent was registered. So that should be why that revenue should be considered as well. Thank you very much. So now our panel will have discussion. Our arbitrators are going to have a discussion. But our two arbitrators, so now we are going to listen to our arbitrators' opinions, and given each country's rules and regulations about how these issues are resolved. First of all, I want to thank Honorable Dreyfus for participating. So, Honorable Dreyfus, could you give us your opinion on this matter?
Yes, thank you. First of all, I want to say that it is an honor and a privilege to be invited to participate in this moot arbitration board. And I'm very thankful, and it was kind of adventure to work on this case, and it was also great fun to work on it. My compliments to the brilliant interpreters. Thank you very much. I understood what you said. It was very good. And I'm very impressed by the pleadings, by the high quality of the pleadings of both the counsel of both sides. Now let me make some remarks on the case as I see it in my German view. I do my best to understand the Korean law, but you may understand that it's not easy for me. As regards the relevance of the defendant's guidelines, I understood Article 15, subsection 2, to mean that compensation under a guideline is to be deemed fair and thus materially correct if compliance with certain procedural requirements sufficiently ensures that the compensation is not too low. I held that the defendant's submission that it was not necessary to hear the plaintiff before the compensation was fixed, but it was sufficient that he could object afterwards, means that the plaintiff was not heard in advance at all. And I just heard the confirmation of this as an answer to the question of my colleague from Japan. That, however, seems to me indispensable. I think the employee has to be heard in advance. Now I have learned that Article 15 allows for substantive control. So the question is whether the compensation according to the guidelines is fair. I hold that it is too low. Second point, there's a discussion of whether the sales in country H are to be taken into account. Here I share the defendant's view. It is also the case under German law that sales in patent-free foreign countries are not to be taken into account for the assessment of the compensation. This is plausible to me. Although the employer implements the invention, he has waived patent protection in country H. However, the compensation for an employer's invention is paid just for making a contribution to a patent-protected position of the employer. Under German law, the employer is in principle only entitled but not obliged to register the invention for protection abroad. As a compensation, he must then allow the employee to register the property right there. Next point, contribution of the invention to the overall product. From the German point of view, this would not be an independent point. A separate determination of the contribution of the invention to the value of the overall product, in this case, the fact that the invention concerns only component AA and not the entire end product B, this is not necessary, as this is taken into account when determining the hypothetical royalty rate. Next point, reasonable hypothetical royalty rate. I tend to follow the plaintiff here. Not only does the defendant save the royalty rate for King, but also has the benefit of significant cost reduction. I would also consider here the high royalty rate that Princess pays, 12%. Next point, contribution rate of exclusivity. Now, this is something very hard for me because we don't know that in German law. This difference between the Korean law and the German law is based on the fact that an employer who does not claim a service invention has no right to use the invention under German law. So he has no non-exclusive license as in Korea. It is therefore very difficult to me to put a value on this. Sorry. Revenues from exploitation of the invention through licensing. As regards this point, the plaintiff submits that this amount should be assessed in full, and the defendant argues that only 1/10 should be assessed. I do not think either side is right. According to the case overview, it is true that one does not need the 9 patents of the defendant for the later process to produce B. However, these 9 patents bring a cost advantage of 2%. Therefore, I would tend to argue that of the 12% that Princess pays, 2% goes to those 9 patents and 10% goes to the plaintiff's invention. In my view, that also fits with other facts in the case overview. According to this, the defendant paid 5% royalties to King. She can save that money now. In addition, the plaintiff's inventions brings a cost advantage in the production of B by 5%, so 5% and 5%, that makes 10%. For this reason, I would tend to consider 5/6 of the royalty income in favor of the plaintiff, 83%. The same would apply to the compensatory payment of 500 million won by Queen. As regards the plaintiff's share, I find it particularly difficult to argue under Korean law, as I do not know the criteria by which quotas are determined there. I lack experience, of course. If I had to apply the German guidelines, this would probably result in the following. For the setting of the object, I would probably assess 2 points. As to the solution of the object, I would probably also assess 2 points. And as to the plaintiff's duties and position, one would probably place him in the second or the third group, meaning 2 or 3 points. According to the table that you find in number 36 of the German guidelines, one would probably assess the share factor of the plaintiff with 10 to 13%. The plaintiff share thereof being a quarter, the result would be a factor of 2.5% to 3.25%. So if I had to resolve the case with a view to German law, I would probably end up with a proposal to pay the plaintiff a sum in the order of 350,000 to 400,000 US dollar. If I would try to resolve the case under Korean law, I would gladly agree with my distinguished colleague Lee. Thank you.
예, 대단히 감사합니다. 진짜 좋은 의견 주셨습니다.
Thank you so much for your valuable opinion. Now, Honorable Judge Katsumata, could you share your opinion, please?
Thank you. This is Kumiko Katsumata, Judge of IP High Court of Japan, and I thank you for inviting me as an arbitrator in this session. And I'm sorry for a little bit technical problem for a while. Anyway, I'd like to explain my opinion. With regard to the existence of the defendant's obligation to provide the plaintiff with the compensation for the employee's invention, I think the defendant has the obligation. I understand that the defendant did not hear the inventor's opinion satisfactorily. So, in the light of Article 15, Section 2 of Old Invention Promotion Act of Korea, the compensation shall not be deemed fair. For your information, to talk about the situation in Japan, the Patent Act of Japan has a similar provision of Article 15, Section 2 of Old Invention Promotion Act of Korea. It is thought to be unreasonable to determine the amount of the compensation in accordance with the employment regulation, providing how to calculate the amount of compensation, which corresponds to the defendant guideline in this case. If the amount of the compensation calculated in accordance with the employment regulation is excessively small compared to the amount of the compensation calculated based on the employer's profit gained by making use of the employee's invention patent, even when the employment regulation was legitimately enacted. In this case, the amount of compensation determined in accordance with the defendant guideline is excessively small compared to the amount of compensation calculated based on the employer's profit, as I explained later. Thus, the defendant has the obligation to provide the plaintiff with the compensation for the employee's invention in accordance with Japanese practice. Next, I'm going to explain the calculation, the amount of the compensation in this case. The amount of the compensation should be calculated based on the employer's profit from utilizing the employee's invention patent. The employer's profit includes both the profit obtained by selling the patent invention products and by licensing the patent. First, with regard to the profit from the sales practice, the compensation should be paid based on the defendant's profit gained by sale or manufacture in the country where the patent registered. In this case, sales of device B manufactured in country G and sold in country H should be excluded because the profit from the sales in country H cannot be deemed as the profit obtained by executing the patent. Therefore, total amount sales of device B from the patent at issue is 943 million US dollars. Next, with regard to contribution to the employee's invention, the contribution ratio of the invention is to be determined taking into consideration the technical importance of the invention. In this case, the patent at issue is much more important than the other 9 patents in the light of the following facts. One, the patent at issue relates to the earlier process, which requires 2/3 of the production cost, and the rest 9 patents relate to the later process. 2, the share of device B has increased greatly after the invention. 3, the defendant was able to enter into the cross-licensing agreement with Clean Company after the patent registration. 4, the plaintiff is awarded as the inventor of the invention at issue by the Prime Minister of Korea in 2014. I assume that the contribution of the invention at issue 70% by taking into consideration with these facts I mentioned. Next, with regard to the hypothetical royalty rate. In this case, the defendant agreed with Princess Company granting non-exclusive license for patent relevant to device B. And in this contract, Princess Company should pay 12% of the sales as a royalty for defendant's 10 parent, including the invention at issue. The defendant should have to pay 5% of sales as a royalty to King Company for a parent to manufacture component A before the invention. In addition to the conditions of these contracts, taking into consideration the average royalty rate 3% in that industry, and of the importance of the invention among 10 parents related to device B I mentioned before, I assume that 5% of hypothetical royalty rate is reasonable to apply to this case. Next, with regard to the contribution ratio of exclusivity, I think 30% is appropriate, taking into consideration the fact that the share in Korea of device B has increased from 10% to 55% or 45% after the invention. And the defendant effort for mass manufacture and mass sales has been a significant contribution to the increase in the market share in Korea. And defendant's 10 parents, including the parent at issue, makes it possible for 5 companies who retains parents related to the component A to form a high parent barrier. So moving on the profit from license agreement. With regard to the license agreement with Princess Company, there is no typical way to estimate the profit related to the parent at issue. However, from my point of view, the profit can be calculated with the contribution ratio of the parent. In this case, the contribution ratio of the parent at issue among 10 patents related to device B is 70%. So the profit is calculated as $70,000 US. Then, with regard to the agreement with Queen Company, 500 million won can be deemed as a license fee practically for the 10 patents related to device B, even if I consider the answer of the defendant in the Q&A session. In this case, I will use the contribution ratio of the patent again and calculate the profit as 350 million won. Next issue is inventor's contribution ratio, or the level of the employer's contribution. As to the level of the employer's contribution in this case is, I think 95% is appropriate, because the defendant's contribution for the profit is huge, taking into consideration the process of the invention, and the defendant had invested a huge amount of money to research and commercialization. Therefore, the inventor's contribution ratio is 5%. And the plaintiff's contribution ratio to joint invention is 25%. It is undisputed. At last, according to my calculation using all factors I mentioned, the compensation for self-practice shall be $123,768 and 75 cents, and compensation for the license is $4,623 93 cents, and plaintiff was already paid $10,750. So as a conclusion, my opinion is that the defendant shall pay the plaintiff $170,642 and 68 cents. That's all.
예, 잘 들었습니다. 이제 이상으로 독일
Thank you very much. So we listened to the really valuable opinions from our arbitrators from Germany and Japan. Each country has different traditions and practices as to how to calculate the compensation. So thank you so much for your valuable input. And I believe that both amounts are very fair and reasonable. And I think that will give us a great reference point for us here in Korea. And we need to now submit the proposal for both parties. So can we see the slide, please, on the screen?
예,
Yes, Yes. Thank you. So we had some calculation. So whether this is fair compensation or not. So as both arbitrators mentioned, that the given compensation was not fair. So more amount needs to be given to the inventor. If I can go over each component of the compensation. So the self-practice profit. As you heard, so the majority here agrees that we need to exclude the $215 million. But other than that, this amount is going to be is calculated as the revenue of this employer. So, but once again, this is the issue that we need to keep talking about in the future for actual practice. As both parties mentioned, as both parties quoted some precedents in Korea, so there's still many issues to discuss. And those precedents are different cases, of course, so they have different circumstances to consider. So this is still an ongoing issue in Korea. And next, contribution by the employees, invention, 80%. So we come to 80%. There are other patents that made a contribution. So this 80% is what we came to. And hypothetical royalty rate, 5%. We arrive at 5%. We believe 5% is reasonable. And the contribution rate of exclusivity, in the case of Germany, they have very specific formula to calculate this. So it might be different from what we used here to arrive at 30%, but we arrived at 30% here. So total profits, as you can see here, $11.316 million. So inventor's contribution ratio is the next item. So this was really hotly debated here. In the case of Japan, we heard 5%. So 95% seems to be given to the employer in Japan. But in the case of Germany, as we listen to Honorable Dijkvans, there's a concept of the employee's stake. So the concept setting is first stage, task is set first, and then there are other steps to calculate, for example, the object and the solution and the contribution as such. So each element is evaluated, and then each element is given a score. So we saw that very specific formula that is used in Germany. So given both countries' formula, we came to 10%. But again, so 10% probably might appear to be higher for the Japanese standard. So I believe some scholars criticize this. So in Japan, we understand that sometimes even 5% is considered high. But here we also need to think about civil law as well. So it really boils down to how honest and how accurate the employer's revenue numbers are. So that's a really key point here. So in conclusion, we come to 10%. And ratio to the joint invention, 25%. The plaintiff's contribution ratio to the joint invention, we arrive at 25%. The compensation is here, $282,900. And licensing agreement compensation, that was most difficult part for us to calculate actually. So when you self-practice the patent and also give the license to third party, so what should be considered as exclusivity, the profit from exclusivity? How should we determine that? So I think that boils down to the license. That's what many academia discuss. So for example, some people say that there's no exclusivity in that case, but others have different opinion. And here, so this is again hotly debated topic, but we believe that exclusivity exists in this case. Then we need to think about the contribution rate of the exclusivity for self-practice. But again, exclusivity here is a kind of two sides of the same coin, exclusivity and self-practice. So that's how we consider this element, and we looked at the Princess company's royalty, so 60%. So we decided to recognize 60% of what the princess's share. So we believe that that's kind of a good basis, and based on that, we looked at the inventor's contribution and also joint invention contribution. And we, for Queen, we came up with 500 million in Korean won. This was also difficult to calculate because this is a cross-licensing case. So it means that even future royalty is included here in this cross-licensing arrangement. And also, we are talking about 10 patents in one product. And also, except this one patent, there are other replaceable substitute technologies as well. And also, we also need to think about the substitution as well, and also future royalty amount as well. So it was very difficult to calculate this, and we talked about this a lot because in the case of cross-licensing, the license that we give and the license that we receive, we also need to calculate it all together, and we need to get the net amount to see if there's a profit or if there's a benefit. So that was very complicated, and so we determined that there is a less exclusivity profit from Princess. So that is how we arrived at this amount. And we looked at, so we came at this amount, $285,350 for the total compensation. But then again, $10,750 is already paid. So if you deduct that, then the remaining amount to be paid to the plaintiff is $290,000. So this is the proposal that we want to put forward. So once again, thank you very much for our arbitrators, Honorable Daifas, particularly because we understand that this is a very late time in your time zone. So thank you very much for staying with us. And also, we thank you for your really high quality opinions as well. So Honorable Daifas and Honorable Katsumata, we hope that we can keep exchange ideas. We hope to exchange. We hope to continue to learn from the continental laws as well. With this, we'd like to conclude this mock arbitration. Employers' invention is really a big research topic at the court, patent court in Korea, actually. So once again, thank you so much, Honorable Daifas and Honorable Katsumata, for being with us till the end and for your very valuable input from your countries. Thank you all very much.
예, 대단히 감사합니다. 이것으로
Thank you very much. That was the end of the moot arbitration. The panelists from Korea, Japan, and Germany, and all of the counsel for both the plaintiff and defendants, please give them a warm round of applause.
예, 어제부터 이틀간 진행되었습니다.
This conference, which began yesterday, dealt with compulsory licensing, trends in IP, and copyrights for a program. And on day 2, we looked at employees' invention and calculation of compensation through moot arbitration with panels from different countries. We looked at important key issues in the IP field. We had heated debate and discussions. It was held both on-site and virtually, and it came to a great success thanks to none other than all of you here and all of our online participants' unwavering support. I would like to express my deep gratitude. Lastly, we will hear the closing remarks from Seo Seung-yeol, the Chief Presiding Judge of the Patent Court of Korea. So please give our presiding judge a round of applause, please.
방금 잠깐 우리 존경하는 특허법원장님 엄마주로 개회사 할 때.
So I wanted to imitate the opening remarks by the Chief Judge of the Patent Court. So as we close the conference, I would like to give special thanks. Well, there were a lot of uncertainties with regards to the date, the location, the timeline for organizing this event because we are still going through COVID-19. But one person was greatly dedicated and made this happen. It was the moderator, Judge Chung Hee-young. Please, I'd like to invite her to the stage. She's the one who made this possible. Compared to last year, we were in dire circumstances, but she managed to achieve this conference, which was even more successful than our previous conferences. So let's please recognize her effort with a round of applause. Now, finally, I'll start my closing remarks. Yes, I am a bit relieved that this conference is actually coming to an end, and I'm quite nervous, so I will try to stick to my script here. So, good afternoon. I am Seo Seung-yeol, the Chief Presiding Judge of Patent Court of Korea. This now marks the end of the 7th IIPCC. We looked at trends in IP litigation, compulsory licensing, AI-related challenges, copyright for programs, and employee invention, and reaching harmony between interests of the employer and the employee's interests. We held the conference under the title Court IP and Harmonization, and it was a very fruitful event. We had to meet virtually due to COVID-19. It's very regretful, but it makes me even look much more to the following years for this conference. And I would like to thank all of the distinguished judges and participants and all the panelists for all sessions and all of the attorneys and patent attorneys. So this really marks the end of the 7th IIPCC conference. I really wish I could see everyone in person for our next conference. Leslie, I would like to shout out the slogan for 2021 for the Patent Court of Korea. I wish all of you to be rich. Thank you.
예, 수석부장 판사님 따뜻한 말씀 감사드립니다.
Thank you for your warm remarks, Chief Presiding Judge Saw. So this online and offline conference that took place for 2 days is finally coming to an end. I would like to thank all on-site participants and online participants once again. Until I meet you again, I wish you health and happiness. So 2021 International Court Conference is closed. Thank you.